Sitting 10:45, sir. ಅಭಿಷೇಕ್ ಮಾಡಿ ಸುಮ್ಮನೆ ಬಂದರೆ ಒಕ್ಕಲಕ್ಕೆ ಮತ್ತೆ ಹೇಳಿದ.
Number 2. killed
Bit matters.
Is the match for tomorrow, my lord? Is that
The work order will be issued on 25th, my lord. That is why there is urgency. Lordship may take it up on 23rd, tomorrow or day after, my lord. It's a writ appeal, yes, fresh matter, my lord. Interim order granted earlier was vacated by the learned single judge, my lord, even without a application for vacating stay. No, it's a state, my lord. Tender is against this. Obliged.
Writ appeal, my lords, in respect of the order passed by the land single judge, my lords, common order. Wherein, my lords, bike taxis have been prohibited from operating in Karnataka. My lords are hearing the appeals, my lords, tomorrow. Other appeals are coming up tomorrow. This one such appeal will be taken up tomorrow. Great.
Lords, in commercial appeal, execution petitions were sued for recovery of the amount. My lord, supply was made but there was delay in supplying. My lord, against that, the respondent's appeal is decreed. Against that, my lord, I filed a commercial appeal. Execution petition is listed on 3. Yes, my lord. 3/7, my lord, 25.
Sir, objections complaint ಮಾಡಿದ್ದೀರಿ sir.
It's all complied. Caveator is not. Caveator, my lord, is lapsed.
So kindly, contempt petition, my lord, 2024 contempt petition against the order passed by the single. Contempt is that, my lord, yes, my lord, next week at least, my lord, 2024.
Yes, but request from during the course of this week. So what is the urgency? Because elections have not been held for the last 10 years. Elections have not been held for the last 10 years. To avoid elections being held, I'll comply with the objection. First, remove the objection.
My lord, writ appeal fresh matter, my lord. I have complied with the office objection and all, my lord. The respondents are, without passing of the award, they are intending to take possession of the land for formation of the road, my lord. Writ appeal, my lord.
Was the order passed?
My lord, order was passed on during the month of March 2025, my lord. My lord, they are taking police protection.
Why are you taking so much time? When you take it,
My lord,
you should also be.
please.
My lord, it's a contempt petition arising out of the order of the Honorable High Court on 13/11/2025. They are not complied, my lord.
It's a commercial appeal which was filed in February 2025. All the defects have been complied.
Yes.
All the defects have been complied. Office objection has been complied, and the respondent has filed an execution petition which is listed on the first week of July. Therefore, this matter may be listed for us. We have appealed and filed an interim application for a stay on the impugned order of the commercial court. Urgency is there. Filed an execution petition, Lordship, on first week of July, Lordship. Any date, convenient date may be provided. Yes, Lordship. We have complied with all of this.
My lords, this is a writ appeal, fresh matter. All the objections have been cleared with my lords. The respondent herein had invoked the writ jurisdiction and sought for regularization of their employment. And the single bench had allowed them, my lords, and had granted 3 months' time for us to actually pay the financial monetary benefits to them. And we were just granted appeal. This is a writ appeal, my lords. Kindly have it listed next week, my lords. The applicant, they might file a contempt against us. Not yet, my lords. That's our apprehension. Kindly have it next week, my lords. Not yet. Yes, my lords.
Your Lordship, this is a writ appeal where my lord had directed to approach the tribunal by filing appeal within 8 weeks. Appellate tribunal, suspect, Your Lordship. So there is a 1 day delay in filing the appeal, so the tribunal has insisted to get the delay contempt from this honorable. Writ appeal, Your Lordship. Writ appeal. Yes, yes.
Filed an application.
Yeah, we have filed application.
So now what are you mentioning?
I wanted the IA to be heard.
Yes. My lord, one matter for tomorrow, my lord. The respondent has filed money recovery and specific performance of the contract in the regular court. Sorry.
He's losing patience.
Yes.
Yes, one matter for admission and consideration of.
What is the nature of the?
My lord, OS has been filed by the respondent, my lord. Specific performance and money recovery, my lord. It is in filed in the general court. Yeah, I filed an application for Order 7, Rule 11 and maintainability of the jurisdiction of the court, my lord. I seeking for transfer of the said case to the commercial court, my lord. My application and memo, 2 times I filed, both the IAs rejected, my lord. My, yes, objection removed. Tomorrow they fixed it for the final here.
You will say so. You filed an appeal. We will not have it tomorrow.
Any other date may be short.
Give you a date.
Yes.
Mr. Prakash will give you a date.
Sir.
There is a memo.
Yes, this is.
Objections removed.
Yes, my lord. Yes, my lord. Yeah.
Why two memos?
There are 2 connected matters, 175 and 176.
Both same.
Yes, yeah, both same. Parties are same. Every.
Is it a commercial dispute?
Yes, commercial. That is a transaction between the in respect of the film theater, my lord.
But what did you file?
I commercial application, my lord. Transfer of the said suit to the commercial application.
But then you have to file not this thing. Commercial. This would not be a commercial dispute.
My
It would not be a commercial appeal, Mr. No, till such time the issue is decided.
This is decided by who? Regular court, isn't it?
a regular court, my lord. I filed an application before the court, my lord.
That will not come here. You have to go before the concerned appellate court.
Yes.
It was normal civil suit. So he has not decided whether it's a commercial dispute or not. So it will not come here. No, just 1 minute. Just 1 minute. So we just give it back. Think over it. You're getting the point?
Yes.
How will a commercial appellate court will have a jurisdiction when it's still not a commercial dispute?
Section 15 of the commercial code.
At such time, it is decided, you will go to whichever is the appellate remedy, you will decide that.
My application for was rejected by the trial court, my lord.
It's not a commercial dispute.
That is a commercial dispute, my lord. But they filed the original suit against me, my lord. My
To the court, it is not a commercial dispute.
yes.
So you will work out your remedies. Okay, next.
I make the application. That application was rejected by the trial court.
Which is right. So rejected means it is not a commercial dispute. If it is not a commercial dispute, no commercial appeal. You are presuming yourself to be a commercial dispute and you are filing a commercial appeal. 1 minute. We are clear, Mr. Prakash. Think over it.
See.
After 3 months, on 20th November, the bank issued a show cause notice to the petitioner stating as to why coercive action I own account as God, because therefore I am, have you filed, I filed a civil contempt petition against the consumer bank. They are taking coercive action before the inter-alia authorities. Because they have given me 21 days of time to show cause notice. We have already filed a reply, but now we have received another notice that they will be taking action my accounts. Let we'll see. But the urgency is that my civil score is being affected for each month. When was the last show cause notice issued? No, it was issued in the month of March 21st. Where are we today? It's all
My lord, sir, writ appeal, my lord, sir, KLR matter, where the single judge, after 50 years, sir, my khata has been changed in the name of the respondent, my lord, sir. There is a chances of creating third-party interest over the property, so kindly
Sections removed.
remove.
Malice
Much obliged.
is a KDB matter, my lords. Writ appeal. All the complaints are complied, Your Honors.
The writ appeal was dismissed for non-compliance of office objection, as there was a preemptive order. I have filed a IAM. The matter may be closed.
My lord, a contempt petition, September 2024, an order was passed to do the needful within 1 month, my lord. There was a change in the Special Deputy Commissioner's office. I sought permission and changed the name also. It is now to be listed, my lord. Yes, my lord.
Let's say contempt petition, fresh matter. Objections are cleared and it's numbered. On 10/15/10/2022, I'm placed under suspension. So about 2.5 years later, I'm still not reinstated despite the order of suspension being quashed and there's no order of extension. The urgency is, next week is the departmental promotion committee meeting for consideration to the next higher cadre. Now, since I'm not reinstated, my name will be placed in sealed cover. Since 15/10/2022, I'm in. The order of the division bench of this court quashing the order of suspension. The order of suspension is dated 15/10/22. My request for next week, since the DPC is meeting on the 4th of July. 4th of July, is the next date fixed.
Was the date fixed?
I'm not certain when the date was fixed. Great.
My lordship, a writ appeal 798 of 25, my lordship. The matter is reserved for orders. It's an education matter. Reserved for matters. Writ appeal 798 of 25. I am appearing.
Rounding of
Yes,
my
my
lords.
lordship.
He's
So I am appearing for respondent number 1. So she has attended the exam in the June and she has passed out. So the petition has become infectious. We are withdrawing this.
Please, my lords. No, my lords. Writ petition she wants to withdraw, my lords. I filed given a memo because she has passed in 798.
You want to withdraw this?
I don't want to withdraw the writ appeal, my lords. In the writ, she wants to withdraw the writ petition,
itself.
the relief. In the writ, she does not want to press. She does not want to pursue any.
So because of this withdrawal of petition, you are
Writ infructuous, my lords. Please. Only one matter. There are about 12 writ appeals.
Except this is only in one matter.
Yes.
Please, only in one matter.
Just take this on.
Grateful.
My lord, writ petition, it's a PIL, where this Kaveri Amusement Park and Disneyland is on question. And the last date appearing, my lord, directed the authorities to place and record the Dam Security Act, what is the measures they have taken. The date is fixed on 26th. There is one other notification regarding Kaveri Arati. That's also under challenge. The entire writ petition is filed. All the office objections are also removed, my lord. 26th, this matter also be connected so that it will ease the court to know the facts of the case. This matter should also be connected with the 26th. Date given is 26th. So this matter also be called along with that. This is Kaveri Arati. Arati at the cost of, please, no. Now this is connected matter. This is connected matter, not connected. On that day, there is that matter is posted. So this also be posted so as to. This is a fresh matter. All office objections are removed, my lord. 20. That's what. I am able. Now another Kaveri Nigama Mandali is Bhimanna. I have served a copy to him and he has already. Much obliged, my lord. Yes, sir.
My lord, it's a writ petition, my lord. Enter matter, my lord. I have applied for tender and paid EMD of 15 lakh, my lord. While uploading the documents, there was a technical glitch, my lord. Therefore, I was not able to upload it, my lord. Thereafter, I gave a representation to the respondent authority. They have not considered it. I filed a writ petition, my lord. In open court, they have issued an endorsement, my lord. Therefore, I withdraw that writ petition and filed another writ petition challenging the endorsement, my lord. Tomorrow is their opening financial bid, my lord. Therefore, there is urgency, my lord. I am eligible.
What have you filed?
Writ petition, my lord. MMS.
So what is the urgency?
My lord, they are opening a financial bid tomorrow, my lord. If it is opened,
What is the challenge?
the endorsement issued by the respondent authority has been challenged.
What did they say in the endorsement?
You are not uploaded in time, they said, my lord. But it is up. We tried to upload in time, my lord. But there was a technical.
Should have done it 3 days earlier. What did why did you wait for the last moment?
Timings was given.
Timing was given. Yes, it was published long back.
I tried in.
Why did you wait till the last moment?
Because I have to obtain police verification, my lord.
You have to do it.
For that, 21 days is required for obtaining police verification, my lord. Only 29 days time is given. By the time financial bid is open, my
petition there.
When is it opening the financial bid?
Tomorrow, my lord.
Why have come so late?
My lord, on 17th I gave a memo, my lord, but it was not listed, my lord. Though I've given here, my lord. I've removed all the objections.
Did you mention it on that day?
I mentioned it, my lord, because tomorrow is the financial.
Yes.
My lords, it's a written matter, my lords. Land acquisition and Muda matter, my lords. They have passed the demolition order, my lords. That too, I received the notice today morning, my lords. And is the urgency, my lords.
Just take that.
Is the matter for tomorrow?
This is urgency issue.
Lord, they are demolishing my building, my lords.
When they have started.
My lord, they have brought JCB and bulldozer today morning, my lords. We are protesting the same, my lords. Okay.
Commercial appeal, my lord. Commercial appeal, my lord. I have compared with the office objections and the regulator is also with urgency. Execution, they have filed execution. They have filed the execution, my lord.
The date is execution.
30th, my lord.
25 ಮಾತ್ರ ಇದೆ.
We are given 11th of July. You should not say so that it is not listed. They've given you a date on that. We've given you a date. Tomorrow is financial day. It's a different argument. You should say so. It's not like that we have given, you mentioned it, we did not list it. Gave you a date on that. Have it tomorrow. Any caveat there? No, man.
It's for a refund, my lord, for the RERA. I settled the matter because this is a single, I paid the entire amount for it. However, the single judge, it's a liberty to approach the RERA again for the compensation. So he has filed for compensation. He has filed for compensation. The date is fixed in this matter.
RERA
Matter was listed before this court last week for us, and it was admitted, and the delay was controlled.
These are not RERA appeals.
Not the RERA, writ appeals. So what has happened is, before the RERA, before the adjudicating officer has filed a complaint for compensation. It was listed on 18th, and on 18th my objections is taken as nil, and they posted it for arguments on 26th of this week. So I am challenging the very order, giving liberty for them to approach the RERA again. So it may be taken. I filed an early hearing application as well.
What is the urgency?
Again, there is a compensation for, again, the liberty was given, they filed a complaint for compensation. Now my objections are taken as nil, and now the matter is posted for hearing before the AO. Adjudicating AO. 26th. 26, 6, this week. Because I have challenged the very order giving them the liberty to approach the RERA again.
In this
writ appeal, yeah. I had an early hearing application as well in this matter. I filed the early hearing application because the date was fixed in this matter.
The date?
7 it was fixed.
Having the early hearing application on 26th.
26th.
If the respondent in this matter, this is a commercial appeal matters. The applicants have come before this multiple court seeking to set aside the order, the judgment passed by the commercial court in Com AP 44 of 2021, wherein the commercial court had allowed the arbitral award in my favor matters. And it's been 5 years, I'm unable to even execute the arbitral award matters at this court. The applicants have appeared before your lordship, but they've been taking multiple adjournments.
No, have they?
Listed, you can mention it.
What is the date there?
It's not dated.
That's its appeal under 37.
37.
So there must be a date. When was it? Where was it listed?
Listed before your lordship. This is a penny to appeal of 2022.
No, when was it listed?
It's lastly listed in the month of January, if I'm not wrong.
Check out the date. What is the number? Just give us the number. Yes, my lord mentioned.
If your lordships may permit me to mention for adjournment, my lords, item number.
Today's
Today's.
Oh. Then, all the list. Which is your number?
262 of 2022.
Just wait. You just wait.
Mine is item number 80, my lords.
80.
80 in this.
I am for the respondent in this matter.
Another interview stemming from the same impugned order is listed on 9/7, my lords, and may be taken on the same day.
Yes, Lord. I have no objection, Lord. It may be listed along with that.
Just hear the request of counsel. We notify on 9th of July.
9th of July. Much of that.
Great.
Who is the other side? State.
My lord, may I seek an adjournment, my lord?
Just 1 minute.
Serial number 57, my lord, great respect.
Just 1 minute, please. Just 1 minute. Which number you said? At the request of counsel for the petition, complainant. Adjourn to
39.
72, ma'am. Yes, you appear for complainant.
For the petitioner.
Petitioner, what do you want?
No, sir, short accommodation in the matter.
At the request of counsel for the petitioner. Adjourn to
28-8.
call the list, ma'am.
My lord, may I seek an adjournment in serial number 57, my lord?
57.
I have informed the appellant's advocate.
I have no objection, my lord. I appear for the appellant in serial number 57. I have no objection.
At the request of counsel for the
Respondent, my lord.
Respondent, my lord.
adjourn to
About 20 days time, my lord. I have to file rich synopsis.
sufficient time, ma'am, August, September.
4-9.
Grateful.
Obliged.
So you have to file an early hearing.
I'll file the necessary application and move it before my March.
Serial number 1.
Sorry. Number 64 and 65, please.
$64
And 65, please.
So both are not connected, I suppose.
My lord, they're all arising of the common order in a writ petition.
No,
Hence-
60, no. Maybe mistaken. Just have a look on the list.
Please. 1 minute, my lord.
Not 64.
65 and 66.
65 is the common.
Sorry, my mistake, my lord. 65 and 66. It's an appeal of the union.
Fine, huh?
Yeah, 3 matters.
You are also appearing.
Please, my lord, I appear for the appellants.
Appellant DGCA.
Please, my lord. It's serial number 4 is also connected to 66. My lord, learned ASD is leading us in this matter. May I seek for a password? If my learned friend is mentioning for an
My lord, all 3 should actually be clubbed and a date may be given. By that time, they remove the office objections, serve us a copy. I don't know why we are not getting a copy served.
Let the matter be called. Just call him. We'll take it up at 4. Item number 4. Just wait.
My lord.
Since 4, he's asked for a password. Mr. Kamath sir has asked for a password. Let it be taken with 65.
Okay, we'll take it up at 65. Okay? You
My
have
lord.
difficulty.
There is a medical checkup I need to go for, my lord. So I'm only requesting that a date even at their convenience may be provided.
Till then, re-notify it because he has a personal difficulty.
I apologize for that.
Okay? Because 65 will not reach. Do one thing.
In that case, my lord, we have sought for a stay of the writ petition. Therefore, my lord, since he is appearing, my lord, may I request that it may be taken at 4 o'clock, my lord.
My lord, any date convenient to them after 27th, I'm happy to
If he
cooperate.
gets free, who Mr. Kamath is appearing, ASG,
Please.
just ask him to come so that he is relieved. He has to go for a medical. We'll take it up when he comes. Ask him to come, we'll take it up.
2:30.
Not 2:30. The moment he comes, we'll take it.
First half is not there.
Oh, first half he is not there.
My lord, they have no grievance. Our aircraft have come to a stop. So the union has no grievance at all.
His anxiety is you may not seek the implementation of that order by filing any contempt or so.
No, contempt has been combined there, my lord. On their request, contempt has been clubbed. So even that anxiety doesn't exist now.
So we'll have it after 2 weeks then at his request.
And my only request is they may kindly serve us a copy, my lord. We are entitled to that.
Are there any other petitions which are following this?
Only 3 petitions, ma'am.
66.
Your anxiety is insofar the stay, contempt is in any case there. But any other petitions which are being filed on which, just say that at the request
This
of-
court has resolved their contempt anxiety, my lord.
What is you are appearing for? Respondent?
Cavator respondent in 4, my lord.
At the request of counsel appearing for the respondent number 4. Caveator is 1 and 2.
Seal number 4. Seal number 4.
My lord, in serial number 4, we are respondent number 1.
1 and 2. And how are you in 65 and 65.1? You are also the same party?
Please, my lord, same party, that is DA Palni Velu and
So, re-notify on. Just first take 4. Re-notify on. Give it after 2 weeks. Just immediately after 2 weeks.
May I request?
And then in 65, similar on the ground of his personal difficulty, just say that. 65, 65.5, a request for adjournment is made on behalf of 1 and 2.
please, my lord.
In 65 also.
Please, my lord.
In all the 3 matters, contempt, writ appeal.
No, what will happen to 66? Who appears in 66?
My lord, I also appear for in 66, my lord, the cable.
Also for 1 and 2?
Please, my lord.
Sure. No, 1.
One. Agni
One. But did you mention it to the other side? Who is R2, R3?
Lord, they all been served, no note, they all been served, but no order has been passed as yet, my lords. I'll inform them. They've been served, no one appears.
Adjourned to after 2 weeks. Same, ma'am. Request in 65 and 60. 65 request on behalf of respondent number 1. And similarly in 66 also respondent number 1.
9-7.
Re-notify on 9-7.
Obliged, my lords. My lord,
On the ground of
Filed
his,
along with 65.
on the ground of personal difficulty. We are fixing one single date
Please, for all the,
for all.
my lord, recording that copies may kindly be served.
I'll serve it, my lord. I'll serve it.
Shall we record it? Let a copy of the appeal.
I'll serve it, my lord.
Oh,
I'll serve it, soft copy also to my lord.
yes, do that. Next.
Serial number 1. Serial number 1.
For the petitioner, my lord, the Salon Court has directed the AGM, my lord, to submit a report in respect of the encroachment made by the private respondent 11, serial respondent 11 to 18, my lord. So far, the government is not filed any report, my lord. Yes, yes. So far, if they are not mentioning the my lord, immediately below the case number, my lord, that is in the matter of public interest litigation. That I have to mention below immediately below the repetition number, my lord. That is only one of the objection.
Office objection, you have to comply with the
Yes,
office.
my lord. I have to mention, my lord, immediately below the case number. That is in the case, in the matter of the public litigation. That is 14-1.
Yes.
The litigation, my lord.
Do that.
Yeah, I will do it, my lord. Because, my lord, the private respondent encroaches the forest land, my lord. Even the forest department as well as the revenue department, they are colluding with each other. They have not taken any action. 1 year back, my lord, there is a direction.
Ma'am, what are your instructions? See, you see page 16, ma'am. See page 16. See the photographs. See, that's his grievance. Yes.
On submission, my lord, the private respondents already served, my lord. Their mentioned, their name is not mentioned in the cause.
Office objections be cleared within 1 week. The learner counsel for the respondent number 1 to 10 seeks and is allowed how much time to file reply, ma'am? You must file it 3 weeks positively, ma'am. 3. No, they have been served. They have been served. Despite service, there is no appearance for 11 to 18. There is a report also. When just show us that.
There are 18 respondents. I have taken notice for 1 to 10. 11 to 18, my lord, the causes the less.
No, we will show you. Our report says so.
Sorry, madam.
Very well.
Just I encouraged in the morning.
Where is the report has been given now? He says here. It says 11 to 12 served as per postal order. These are all servicemen. What is this? Where does it say? Service effective? Received it. They have been served. Despite service, there is no appearance for 11 to 18. 3 weeks. 3 weeks. We filed within 3 weeks objections. Just have it after 3 weeks.
Please.
21-7. Serial number 2.
Lord, appearing for the petitioner, my lord, prays for a week's time, my lord, to comply with the office.
Office objection be cleared within 3 weeks.
13-8. Serial number 3.
My lord, appearing on behalf of complainant, my lord, there is one office objection with respect to translation copy. Can it be exempted, my lord? Can it be exempted? I'll comply it, my lord.
Office objection be cleared within 3 weeks.
Much obliged, my lord.
12-8. Serial number 4 adjourned. 5. Serial number 5.
Please, sir. For the impleading applicant. The counsel for the impleading applicant is unwell. I've been asked to take some. Mr. Padma Prasad is unwell for the impleading applicant on IA number 2/24. He's keeping unwell.
Just show me that.
What has happened in this case, Kunal, is
So what do you want?
requesting for a short date, my lord, is unwell. The
Who is
counsel,
unwell?
The counsel appearing for the impleading applicant, Mr. Padma Prasad Nashi.
What do you say? Request for adjournment is made on the ground that Mr. Padma Prasad B. Nashi.
Please.
Padma Prasad B. Nashi, advocate in IA 2 of 24 is unwell. Just give it in here, August, September.
1-9.
I'm grateful.
Serial number 6.
So the respondent 2 in this
To
case, my
appear for
lords.
petitioners, my lord. Lord, this is an important matter which my lord's court has been monitoring for some time. And I must say that small results we are able to see, but this I could say is like a semi suo motu petition, which Lord, we had many
What is the
deaths.
latest report, ma'am?
Yes, my lords. My lords, we have obtained the documents. The concerned person who was supposed to sign the affidavit was not available. Hence, we pray for this week's time. On next Monday, we'll file it.
But you have filed any additional affidavit? You show which are the critical areas?
Lord, all city areas are critical areas.
No, but the degree varies.
We can file that. The recent one, maybe we can file that.
Continuous rains, everything, that wear and tear is there.
Lord, the concern is this. The concern, Your Lordship will kindly see the latest order of this honorable court on 21/9/2024. Lord, it's not that we are also wanting to close this petition, but the minute there is no my lord, that domestic sword on the BBMP, my lord, the roads go really bad.
We do one thing, no? You
Please,
must also.
we'll be guided by what my lords are going
No,
to say
what
now.
we are saying is, at least, this is something need to be, told to them also. They may cater to one area, the other critical area is also there. They must also look into that
No,
also.
Lord, we are on a larger picture. Your Lordship will kindly see this motion bench order 21/9/2024. I will just take a 2 minutes to read. The petition is filed in 2015. The earlier reports filed on behalf of the respondent do not disclose the latest position in terms of steps taken by them to deal with the issue of dilapidated roads and potholes. We want a comprehensive machinery as to how they are going to do it, which they did 2-3 years ago, but they're not following that. They're again going back to putting, once you see a pothole, they go and put mud and something in that. Though on paper they say they're having some very scientific method, but on ground they're not doing scientific method. So,
They implemented CRRI.
no, my
Road
lord.
research.
We did. There was a report by them also, but they said it is too expensive for them. They cannot follow that.
When will you file your affidavit?
My lords, on next Monday, my lords.
Just say that counsel for the BBMP seeks and is allowed 2 weeks time to comply with the order dated 21/9/24.
Much obliged.
Obligement.
24/7. Serial number 7.
For the last
7.
21. None for the petitioner adjourned to.
2/9. Serial number 8.
I appear for the complainant. Your Lordship,
What do you say?
they have just given a letter saying that they are entitled, but no monies. There are 84, 83 years old. They should get arrears from 96, nearly 18 lakh. They are not filed the compliance affidavit.
This one.
On 2nd of June, my lords, the refixation of pension was done. So it served a copy. Now they're seeking for a compliance report in that regard. If that be so, I'll file a compliance report also.
Compliance report be filed within 4 weeks.
Your Lordship, they are at the deathbed, 84 years. It may be shorter date, may be given because they have to get.
It's all right, let's file it. They are getting pension.
Yes.
It's only the refixation.
Even
No,
that's
it's
been
a huge
undertaken.
amount. 18 lakhs they have to get each.
That was also
They're-
redone,
they're-
my lord.
As a final.
Refixation
And no
was
interest
done, my lords,
for
procedurally.
that period.
See, it's like this, my lords. We say nothing on interest. There is nothing in that order.
No, judgment says no interest for me.
That's right. So, as a last opportunity, you will do it.
My lords, we have refixed it.
The use of refixation.
The benefit has to flow to them is the grievance. I'll ensure that is also done consequential to refixation of the same, my lords. I'll file the compliance affidavit in 4 weeks, evidencing that also, my lord.
Speaking, compliance is only to the claim, to consider their claim.
We have considered, we have refixed it positively in their favor, my lords.
See, this doesn't really, if you are legally, there is no contempt now. Once they have fixed the pay, pension, refix, they will pay it.
Date may be given.
We will give you date, 4 weeks, after 4 weeks. Give it to August.
6/8. Serial number 9. Party in person.
Yes, Mr.
Complainant
Patil.
party in person in this matter. They have filed their affidavits, but according to me, there is no compliance.
What is your this thing?
Please, my lord. Annexure A is the order passed by the division bench of this honorable court. At page 16. And the direction.
What has to be done?
According to me, my lord, as per the direction of this honorable court, certain mitigating measures had to be adopted by them. They have not done that.
We have done, my lords, comprehensive affidavit along with 9 annexes have been filed. This pertains to the Jakkur aerodrome, my lords. So this is the runway issue, what happens. So the runway issue comes into play if there is further construction in the road abutting to the Jakkur aerodrome. Jakkur aerodrome is abutting the national highway as such. So there are two projects which have come up. One is the national highway, the other is the metro line, my lords. So that is considered as the obstacles for the flying of the aircraft as such. So there are two measures which can be implemented when such obstacles are noticed, my lords. One is to remove the obstacles. It's not possible in the current scenario. So we redo the runway, my lords. That is the distance what the flight takes in the land as such. So the redoing of the runway is done in consultation with DGCA. On the recommendations of DGCA, we have refixed the runway path, and thereafter NOC was to be issued to BMRCL, that is the implementing authority with regard to the metro line. So we are bound by the runway refixation. DGCA is the expert authority. On taking the opinion of DGCA, as per their recommendations, we have redone the runway length as such, and there's an order passed, executive order passed with regard to the refixation of the runway length. Thereafter, a meeting was held wherein consequentially NOC was given to the BMRCL. Annexure R7 is appointed to the.
We will hear it.
As very much, my lord.
List the contempt for hearing on after 4 weeks.
A shorter date, my lord, because the pillars have already come up, and without adopting the mitigation measures suggested by DGCA, they cannot put up any construction in the
But are you
direction.
saying they have not followed the DGCA?
They have not. They have not.
Who
That is
appears
my-
for DGCA? Is DGCA party here?
This is BMRCL is the one which is putting up the construction.
No, you're right.
DGCA, I have made them formally a party.
But you have made DGCA party.
Yes.
4 number.
Notice had to go to them, my lords.
Notice has been issued.
No.
Not yet.
Just say this.
No, DGCA is not a party, my lord.
Mr. Patil, where is your contempt? See
Contempt
page,
is, yes.
page
Contempt,
3.
the state government.
Who is the respondent number 4?
I'm appearing for respondent.
That's the DGCA, my lords.
That's right.
No, he was the director of the government flying training school. Respondent number 5.
Mr. Patil, we are on respondent number 4.
Respondent number 4. He is BM. Please, my lord. Yes.
He's an officer of DGCA.
Please, my lord.
Just notice is not issued. Just say that notice. Where is Mr. Kumar? Is he here?
I'm appearing.
Colleague of MN Kumar is there, my lords.
You will file your affidavit and you will give your affidavit to them.
I'll serve a copy on them, my lords.
So and so appears for respondent number 4, seeks and is allowed 4 weeks to file. Reply affidavit. Rest are represented.
Yes, my lords.
After all, government has filed an affidavit on their behalf also.
Chandrasekhar, you will represent the rest?
I will, my lords. BMRCL
No,
and also the Jakkur flying school is nothing but a government agency, my lords. I
So
represent
1,
them.
2, 3, 5 and 6 you represent?
They have filed the affidavit on behalf of 5 and 6. They have filed. Government has filed.
5, 6, 7, my lords. All three, my lords.
So you represent 1, 2, 3, 5, 6, 7.
BMRCL also has a panel council. Mr. Harish would take notice for R3, my lords.
R3.
Yes, my lords.
But government has filed affidavit on behalf of R3. Government has already filed affidavit.
3 and R6.
We have filed, but they also want to come on record as such.
You are for the 3?
R3 and R6 I will, because Mr. Anjum Parvez
Notice
was
served
the.
on them. For 3 and 6. Let notice be issued to respondent number 3 and 6 also. 3 and 6, na?
3 and 6.
3 and 6, yes. That is BMRCL. He is the presenting managing director. 6 was the managing director at the time when the writ petition was disposed of.
But he is the former managing director.
Yes, the office objection is that you have to make them also as parties. That is the reason why we have made them parties.
At the relevant
That is-
period, he
at
was
the
the
relevant
MDs
point of
that.
time.
Okay. For issue notice to respondent number 3 and 6 as well, returnable on.
2/9.
Shorter date, my lord, may I request, because
Let
the
them come,
urgency
Mr.
with which they are proceeding with the construction, my lord, is what ultimately the idea is, my lord. The PIL was all about.
The number, give it in August, man.
21/8.
Oblige.
May I request for 22nd or 23rd of August?
Of August. Oblige.
May I request for 22nd or 23rd of August? 21st of August, I have some difficulty. If it
Just
can be
have
on
it up,
23rd
just
or
have it, ma'am.
Oblige.
22/8.
22.
Serial number 10. K. Vasan.
Just say this, respondent number 4 to file
Complaint, my lords.
affidavit. Notice be issued to respondent number 3 to 6.
They're
My
supposed.
lordships, I appear for respondent. We have filed a writ appeal, my lordships, and that writ appeal came to be dismissed for non-compliance of office objections. And I have filed the recall application also, and I have moved the memo before this honorable court. And this court has fixed a date, listed after 1 week. And so this matter may be taken up on that day, my lordships.
What is the date?
Date has not fixed, but
So we will fix this. We just re-notify this contempt. You get it fixed.
my lordships, the writ appeal and this matter may be taken on.
See, we don't know whether this is this roster or which roster. What is the number of the writ appeal?
My lordships, 992 of 24.
Will be here one. You will mention it through a memo. Was it not listed writ appeal?
It's not listed. writ appeal.
Placed along with this contempt, sir. Dismiss.
So what is this? Acha, this is, oh. Get that application listed. Okay, we are just re-notify the contempt on. On this day, you get it listed.
My lords, at the same time, they may be directed to file a reply, my lords. They have not filed a reply, my lords.
Let the writ appeal come first.
Sure.
Re-notify on. Okay?
13/8. Serial number 11. Shri Madhusudan Rao.
I appeal for the complainants. The case where in 1983, grant certificate was issued in favor of the predecessor title of the complainants. They did not give the Sagavali chit. I filed a writ petition. This honorable court directed them to consider my representation. Thereafter, they did not act. I filed one more writ petition. This is the order passed by this honorable court. This honorable court. Kindly see. Page number 26, para 7. Direction was to issue this Sagavali chit after assessing the lands, asking the number of trees, and if the trees are older than 40 years, government should take it. And if the trees are lesser than 40 years old, I should be able to permit it to keep quiet, and the Sagavali chit should be given. What the government has done is, they have now issued a fresh government, almost a temporary Sagavali chit, fixing the market value on the present day market value, which is totally contrary to the directions given by this honorable court. Kindly see the order, para 7 of the learned single judge's order, page 26.
What are your instructions?
Para 3, page 22, my lords. This was a conditional Sagavali chit, my lords. So he was not put into possession with regard to the Sagavali chit issued as on that day. Because Malkis, what we term in the revenue language, had to be removed by the forest department. That never came to be done. Because of the consequential writ petitions fixed.
So did you file any appeal against this?
No appeals been filed, my lords. One is, there was a Sagavali chit, para 3 for a moment, my lords, para 3 of the order as such. He was not put in possession.
No,
of the
it is
lands
not
in
so.
issue,
That is
my
not
lords.
the case,
Yes,
It's undisputed in para 3, the observation in para 3 of the writ petition order, page 22, my lords.
But how would you say the chit shall be issued in favor of the legal heirs? Is it just a positive order?
My lords, the father of the claimant who are the legal heirs of the virginal allottee was issued a Saguvali chit way back in 1983. It was a conditional Saguvali chit, my lords. He was not put in possession because Malkis, that is the forest department, is the concerned authority to remove the Malkis as such. So with regard to the consequential act of the Malkis being removed, forest department did not do the same. So consequentially, writ petitions were fixed that you act on the Saguvali chit of 1983. Then directions were given. Then it did not flow. Further actions were also not taken. Then one more writ petition was filed. Now the forest department has come up with a say telling that it doesn't contravene the orders passed by the Supreme Court in the Thirumalpath case. Hence, we can go forward, and with regard to removal of Malkis, it can be conditional. 40 years and above trees, we are going to reserve it in favor of the state. Others, we are not going to reserve it as such. So thereafter, now Saguvali chit has been issued, my lords. Their grievances, Saguvali chit, there is an upset price fixed as on today's date. They say upset price has to be fixed as on 1983. So we have issued the Saguvali chit. Now they are aggrieved.
But tell us one thing, now, if that be so, then the order has been complied with.
Yes,
No,
they have to challenge the wires of the Saguvali chit, what we have issued as such.
I will clarify things. What has happened is this. My learned friend is wrong when he submitted that a Saguvali chit was given earlier. It was a grant order. It was not a Saguvali chit. My grievance was Saguvali chit has not been issued. There is a distinction between grant order and Saguvali chit. Grant order was already issued. In fact, may I kindly see the order.
You have not issued Saguvali chit.
No, he had not issued the Saguvali chit. Now they give temporary Saguvali chit. They are issuing temporary Saguvali chit, fixing the market value as per the present day value, which is not the direction of this honorable court. They are going beyond the directions.
No, but tell us one thing.
Yes, Milad.
But Saguvali chit presupposes in law.
Yes, grant.
The certain money to be paid.
Yes, what I am submitting is in the grant order, which was earlier given in 1983. The amount that has to be paid has been fixed. 800 rupees per acre. That was the amount that was fixed in 1983. Thereafter, only thing that they had to do was giving Saguvali chit by removing the Malki, that is the trees. They did not do so. We filed a writ petition earlier before this honorable court. This honorable court directed them to consider my representations. They did not do so. One more representation was filed subsequently in 2019. That was disposed of in 2022 with a specific direction that you have to give Saguvali chit, and they did not, this honorable court did not give them any liberty to fix the market value as on the present day value. The only thing they said is, if the trees are older than 40 years, that should be left with the government, reserved for the government. If the trees are lesser than 40-year-old, then that day I should be allowed to keep them, and I should be given the Saguvali chit. Whatever they have done now, as per this present order, is in clear violation of the orders of this honorable court, because this honorable court did not permit them to fix any market value afresh. Only this honorable court said this much: find out whether there is a grant order in 1983 or not. They are not disputing that there was a grant order in their 1983. Now the question is, once the grant order is there, the consequence is issuing the Saguvali chit. They are going beyond the order. 1983 onwards, they have been struggling. This is something beyond the
observation that the upset price as on that date should be fixed, my lords.
That order.
Which order, Milad?
The one which they have issued.
Now they have issued, Milad. I have to go file one more writ petition. As on the face of it, Milad, kindly see the order, Milad.
No, one minute. Who would decide it whether they could have claimed the charges on the basis of 1980 or today?
No, my submission is this. This honorable court gave a specific direction. Kindly see the direction. If the direction had permitted them to fix the market value as on the present day, Milad, I could have understood.
It's not say otherwise also.
Kindly, I'll read the order once again. Let us try to go there. Kindly go to para 7. Consequently, this writ petition stands disposed of with a specific direction to the Deputy Commissioner Chikmagalur to secure the original records regarding the order bearing number LND CR 13/1983-84, dated 29/4/83, and on satisfying himself regarding the genuineness of the order passed by the then Deputy Commissioner, issue necessary directions to the Tahsildar to issue the grant certificate bar Saguvali chit in favor of the legal heirs of Sri Huappa Shetty, as suggested by the Tahsildar in his communication dated so and so. If there are any standing trees in the land in question, the rights in respect of such trees which are older than 40 years may be reserved to the government. If there are any other trees not older than 40 years, the government will have no right to reserve such rights in its favor. The Deputy Commissioner shall take note of these aspects and pass necessary orders for issuance of the grant certificate by Sagubali chit. The Sagubali chit shall be issued in favor of the legal heirs of Sri Bhuyopa Shetty as expeditiously as possible and at any rate within a period of 3 months from the date of the receipt of the copy of this order. This was the order. And kindly see the.
But tell us one thing, there are no conditions attached to it.
My lords, there's not a positive direction that the upset price should be fixed as on 1983 also. my
Even
lords.
that is true. Even there is no direction for upset price also, but in any case, you have fixed it.
They are told that Saguvali chit / grant certificate is to be issued. The contents of the Saguvali chit is disputed now, my lords. That's the upset price fixed in the Saguvali chit.
Is it as on 29/4/1983 or the fresh one?
Fresh one, my lord.
Oh.
Because the Malkis as a precondition has to be removed. That for that the forest department has to clear it.
See, that is why 29/4, whether it is genuine or not, that has to be verified. If it is genuine, then you have to act upon that. You
Yes.
cannot fix a new one.
Agreed, my lords. That grant certificate was conditional. That Malkis would be removed, then the Saguvali chit would be issued. Para 3 would make it clear, my lord.
Here it will fix.
Yes,
the
ma'am. I will do one thing, my lord. I will also produce the grant certificate also, which is very clear that there is no such conditions attached.
Para 3
Yes,
may be seen, my
because-
lords. It's the observation of the court.
List the contempt petition for hearing on. Just give it in September.
The date, earlier date, my lord, from
Yeah,
9.
No, we will just fix a date.
4/9,
Next.
serial number 12, Shri Krishnamurthy, 12.
What is this? Yeah, this need to be
This-
heard.
Yes,
My
but
lords,
the second respondent was directed to consider a representation given by respondent number 325 within
On
4 weeks.
15/5/2025, it's been reserved, my lords. I have direction from the official concerned along with the original record that in another 4 weeks, they are going to pass the necessary orders, my lords.
Lordship may kindly see the direction issued by this honorable court. 4 weeks from 13/7/2022. Now it is 3 years over.
15/5/2025, all
second
the proceedings
respondent-
were completed, my lords. There were cross claims between the original landowner and also the society. They were represented. Last occasion, the landowners have also
Just
appeared,
correct.
so it's been
Now,
reserved for orders,
which
my
is the
lords.
connected matter?
They are 12.1, my lord.
Just say at the request of Mr. Chandrasekhar, re-notify on.
I also sought for initiation of contempt against respondent number 325 for abusing the process of this court.
We'll see, let's see.
21/8. Serial number 13, government advocate.
State appeal, my lord, the service is not complete. my
Let
lord. We will
notice
take
be
necessary-
issued to R1, R2, R3, A2E, R4 and R5.
8/9. Serial number 14.
For the respondent, request for 2 weeks time, Lord, it was supposed to be placed before the committee. Lord, the committee's decision could not be completed. Lord, may grant me 2 weeks.
Please, just say that 2 weeks are granted to file reply affidavit.
Date may be given, my lord.
14/8.
Please.
15, Sri Vinod Kumar.
My lord, for the complainant, my lord. My lord, this honorable court directed the police inspector to act as per Lalita Kumari versus state of UP, my lord, on the basis of my complaint, my lord. My lord, my complaint discloses a clear case of a cognizable offense, my lord. It's a case of forgery, my lord. The accused, my lord, has morphed and forged my video and photos and showed as like I have been arrested by the police in corruption case. I'm a MLA in that area, my lord. He has published everywhere, my lord. I have lodged complaint, my lord. They have not taken any action leading to the political motivation, my lord. My
What
lord,
do you say?
Compliance affidavit is on record, my lords.
they say, my lord, it's a non-cognizable offense and they have asked me to give some document. I did not give document. Therefore, they are going to.
File a rejoinder to this then.
Please, my lord, I have filed rejoinder. my lord.
Rejoinder be filed within,
In the meantime, let them reconsider, my lord. They have to only register FIR.
no, first file a rejoinder.
Please, my lord.
Rejoinder be filed within 4 weeks.
Please. No, my lord, within 1 week I'll file. because there is some urgency there.
Within 1 week, just give the normal date.
39. Serial number 16, Shri Rakshit Kumar. 16.
Appellant. Within 2 weeks, say 2 weeks.
My lord, in this case, I have filed IA for recall application, my lord. There was some delay, my lord. For that, I have also filed IA for condemnation of delay. There is some office objection, my lord.
How many office objections are there in the appeal?
Yes, my lord, there are around
13.
15 office objections are there, my lord.
Just say that pending consideration of IA 2 of 25 and 1 of 25 and 2 of 25, comma, the counsel for the appellant shall remove the office objections in the writ appeal.
My lord, if lordship may permit, my lord, I'll make necessary changes in that delay, my lord.
First comply the office objections.
29.
I'll
17, serial number 17.
The time for the complaint, let's
Time for the
continue
respondent.
close. Blood, I am for the complaint, bloods. Bloods, complaints affidavit is filed by the complaints, bloods.
Office objections be cleared.
Bloods.
Lord, the order has been complied. Order has been complied.
1 minute, please.
Contempt petition may be closed, bloods.
What?
Time for the,
What are you saying?
bloods, the complaints have filed the affidavit stating that blood, the accused have completed the order of the learned single
Where is
judge.
your affidavit?
Bloods,
Who appears for the respondent?
HL Pradeep Kumar.
I
is
am for the
on-
respondent, my lord. The complainant, my lord, has filed an affidavit on, my lord, 2nd June 2025, saying that, my lord, they have received the DD, my lord, 2nd June.
2nd June, we have filed.
The counsel for the petitioner has drawn our attention to the affidavit filed on
2/6.
It is not clear, ma'am. It is not clear. When did you file it?
2/6 blood, June 2nd blood.
Of this year?
Yes, blood.
This is 20th of May we have.
No.
2nd June.
No, 2nd June I have filed.
It is 2nd June.
Office objections, I have raised objections on that only.
Not on record. They say that affidavit stated to have been filed on 2nd of June. Oh, 2nd June. Okay. An affidavit has been filed on 2nd June 2025 by the
Complaints.
complainant,
Para 7 is
namely Mr. Chaudhaya and Uttaraju and KM Basavaraj, by the complainants. Paragraph 8 of the same reads as under. Pustadalana counsel for the petitioner seeks to withdraw the contempt petition. The petition is dismissed as withdrawn.
Serial number 18, Anant Kumar.
Filed an application for stay and as well as production of documents.
I am appearing for respondent number 4 to 10.
original suit, my lord, that they have filed original suit before the trial court for declaration of 1969, my lord, the partition deed which is executed in the year of 1969. They have filed a suit in the year of 2024. And in the meanwhile, my lord, that they have challenged mutation entry before the assistant commissioner and deputy commissioner. Ultimately, this honorable court, my lord, has said the suit is pending and let it be decided. Till then, whatever, my lord, mutation entry which is passed, my lord, to be continued in the name of the respondent number 1 to 10. That is the order, my lord, which is passed.
So what do you say? This need to be heard?
Yes, my lords.
All are served?
Yes, my lords.
Yes, I read the appeal for hearing on.
8, 9.
All have been served, no?
Yes, yes, my lords. All have been served.
Eight.
Serial number 19.
Much.
Serial number 19.
For complaints,
Come.
lords, on earlier two occasions, my lords, the other side submitted that they will file, my lords, additional affidavit.
I have filed the same, my lords.
Copies of
I'll
additional.
I'll serve the copy also, my lords. Physical copy, they serve it now.
That a copy of the additional
Served,
affidavit,
my lords.
additional affidavit, and a copy of the additional affidavit has been served on Mr. Shrikant, who seeks some time to look into the same.
Lords, may have it, my lords, by next week. Urgency is, my lords, about starting of additional classes, my lords, higher classes in the existing school. Now, my lords, we're in June, my lords, that's the urgency.
Just have it first, we proceed.
16, 7.
Next.
Can it be, my lords, in the month, in this month itself?
Not possible, Mr. Shrikant. Next.
Serial
Please.
number 20.
My lords, in this case, I am for the complaint, my lords. In this case, there is one office objection which has been raised pertaining to the accused has to be represented by the company and its directors, my lords. My lords, in my writ petition, what has been filed, the complainant is the petitioner in WP number 4195 of 2023, my lords. In that case, the accused are respondent number 5 and 6. In that cost title, we have only mentioned the company represented by its directors, my lords.
Now, who is to be punished for contempt?
No, my lords, my submission before this honorable court is that the company, it includes the representatives as well, my lords. I would,
Why don't you include them?
my lords, because again, to ascertain who are the directors, the time of writ petition filing, and now it is quite cumbersome, my lords.
You go to the Registrar of Companies website.
I would just take you to section 12, my lords, of Contempt of Court Act. Just 2 minutes, my lords. Section 12.
I don't know, you must look into this.
No, my lords, in this section 12, I would just take only 2 minutes, my lords. I'll make my submission.
Yes.
Yeah. Section 12.
Read it.
Section 12, subclause 4, my lords. Where the person found guilty of contempt of court in respect of any undertaking given to a court is a company, every person who, at the time the contempt was committed, was in charge of and was responsible to the company for the conduct of business of the company, as well as the company shall be deemed to be guilty of the contempt, and the punishment may be enforced with the leave of the court by the detention in civil prison of each such person, provided that nothing contained in the subsection shall render any such person liable to such punishment if he proves that the contempt was committed without his knowledge or that he exercised all due diligence to prevent the commission. Now, subclause 5, my lords. Notwithstanding anything contained in subsection 4, where the contempt of court referred to therein has been committed by company, and it is proved that the contempt has been committed with the consent or convenience or is attributable
Yes,
to any neglect.
Just 1 minute. On the objection raised by the registry, Learned Counsel for the petitioner has drawn our attention to section 12, bracket 4 of the Contempt of Courts Act, keeping the objection open, issue notice to the respondent returnable on.
4, 9.
My lords, there is one more connected matter in civil contempt petition 1254, my lords. Let it be taken up properly.
We will issue notice, let it come first.
Much of it.
Next.
Much of it.
21. Serial number 21.
I prefer the appellants. In this case, respondent number 2 is the KPTCL, my lord. It is not proper and necessary party. They gave the memo stating that, my lord, BESCOM is the jurisdiction. Single judge was directed to pay the compensation.
Matter is covered by judgment of your lordship.
But what do you say now?
Now, the second respondent is not only formally they made merit in the writ petition. That is why we also made.
What is your case on merit?
A case, my lord, on merits, my lord, they have the deceased Sivakumar was died due to electrocution. I have challenged the petitioner here challenged in the writ petition Annexure M, my lord. Annexure M is correctly issued by the BESCOM, stated that it is the civil jurisdiction because without evidence.
It's all settled now.
No, the Supreme Court citation, my lord, Supreme Court as well as this honorable court clearly stated that, my lord, only jurisdiction is the civil court. Whether evidence.
Thing has been covered now. We in a written judgment went to Supreme Court upheld and against BESCOM. Against KPTCL.
But KPTCL is not proper. And
Different, doesn't make any difference.
no, the second petitioner, what they have given the letter, my lord, in the KPTCL,
See,
only 11 kV.
Electricity, absolute liability.
Yes, BESCOM is the jurisdiction before the KV, 11 kV is, if below 11 kV,
Yes,
it is
show
the BESCOM, my lord. Above 11 kV, it will come the KPTCL. That is the.
We have a look.
Yes, I will give one week, my lord, because this second I will look into next week, my lord, because I will inform the BESCOM, because the KPTCL now it is come for the service, my lord. The KPTCL is filed the second time notice. It is not proper. They are not proper and necessary parties. Because there is single judge also directed.
Party.
Yes, my lord. Even though single judge also directed to pay the compensation to the BESCOM, my lord, appellants.
To the Supreme Court in this.
No, my lord, we have state. No, that is why, my lord, this, what was happened during the negligence, my lord. Negligence is, it has to be proved by the evidence only, my lord.
What was the negligence?
Now, negligence, my lord, they stated, my lord, he went to the field. Electric wire was touched. He died due to electrocution.
Whose negligence? Your negligence or his negligence? The poor man.
No, it is stated that.
Left a family,
Yes.
Not like this. And what has been given? 19 lakhs?
19 lakhs has given to
That's all.
for all family.
And in these appeals, which went to Supreme Court, 49 lakhs.
Because
This will increase it.
only we gave the annexure M, is set aside the annexure M on the ground that the civil court. We only tell to approach the civil court.
That law is well settled. And we have dealt with this judgment also, that law civil court jurisdiction. They are not disputed. The wire was this thing.
Yes.
And he unfortunately put his foot down, put on that wire, electrocuted, instantly died.
It is the act of God, my lord. It is not, it is because, my lord, it is negligently, it's not followed. It is already wire was there. It is touched the live wire.
Don't say
due to
act of God. BESCOM is not controlled by BESCOM people, but by God. That's the submission you are making.
No. And it's,
Why all these employees and staff are there? Leave it on the God.
no, at that time,
Understand what is the submission?
it is heavy rain due to these things, my lord. It was happened.
Young man,
Anyway,
how many?
I'm sorry.
Just imagine parents.
Parents, wife and children.
16-year, 13-year-old children. How will they sustain themselves?
Kindly have it next week, my lord. I'll look into it. Next week.
Want to argue?
I will.
What?
Next week, anyway, I will inform.
At the request of counsel for the appellant, adjourn to.
Lord, it may be ordered to be listed along with 1562 of 24, Lord.
We will give you a date. When is the date? In that 1562.
Lord, it is regarding office objection, Lord.
You clear it, get it listed. Who has filed it? They have filed it.
I have filed, Lord.
Why? For enhancement.
Yeah, enhancement and interest not paid, Lord.
That you get it listed on this day.
Yes.
They have not filed an appeal in that matter.
No.
BESCOM or KPTCL?
BESCOM, my lord. KPTCL is the only formal part.
In that.
In my case, my lord, the claimants have filed.
Who is the respondent?
Respondents very same. my lord.
Descom and KPTC.
Very same. Appellants are respondents.
A notice may be dispensed to respond number 2, my lord.
Okay.
Connected mat 1562 of 24.
You file a memo, we'll get it listed. The request of the counsel for the appellant adjourned to.
21-8.
Notice may be dispensed. Respond number 2. Respond number 2, the KTCL, only formal party we made. Descom is there.
The counsel for the appellant states notice to respondent number 2 KPTCL be dispensed with at the risk of the appellant. It is ordered accordingly.
21-8. Serial number 22, Shri Totad. 22.
3 to 12. A 6-week accommodation, my lord, to comply the objections in the wakalat.
Yes. Just show us the file. Ah. Why don't you remove the objections?
I have filed wakalat for the respondent, my lord. 6 week times, my lord, the names of the respondents was not mentioned in.
You must mention it.
Please,
You don't want like this,
Please,
ultimately
madam.
they come and say, we did not sign it.
Please, my lord,
You want all, the description must be complete.
please, my lord, week's time, my lord.
At the request of counsel for the
Respondent.
3 to 32. Just say that the report has been filed by the Registrar Judicial. We have perused the same. Registrar Learner Counsel for the respondent number 3 to 32 states that the the office objections raised on wakalat shall be cleared before the next date of hearing. Just review it in September.
8-9. Serial number 23, Shri Janardana. 23.
My lord, so there are certain decisions taken on 3/3/25 and 9/5/25. Those needs explanation by means of a compliance affidavit. I shall file the same, my lords.
Which one?
23, my lords.
20.
Just say, what did you say, Mr. Chair?
My lords, there are decisions taken on 3rd of March and also 9th of May, my lords. It needs justification by means of a compliance affidavit. I shall
At
file
the
the
request
same.
of Mr. Chandrasekhar to file a compliance affidavit.
My lord.
Re-notify him.
19-8. Serial number 24.
Appear for the complaint.
Yes.
192, my lord. I pray for 4 weeks for to file, my lord. We challenge the order in the writ appeal, my lord.
You have filed?
Yes, my lord. We have filed the writ appeal, my lord.
My lord, in this case, what has happened is, my lord, this amount has been paid, my lord, nearly after 13 to 15 years, EL encashment and gratuity. My lord, there was one more writ petition, my lord, which is a subject matter of the next contempt petition, where, my lord, the HMT preferred a writ appeal. That writ appeal has already been dismissed. So amount has been paid.
Here also they have filed it now, Mr. Bhatt.
Yes, my
Let the formality need to be completed now.
lord, all that my request is, my lord, some early date may be granted.
We will fix a date, but you just say that learner counsel for the respondent states that the respondents have filed a writ appeal. He also states that he shall get the writ appeal listed within 4 weeks from today.
Yes.
Just give a date. You will get
4-9.
it listed on this day when we are fixing it a date.
Please, my lord.
4-9.
No, don't say 4 weeks. Shall get the writ appeal listed on the date when this court is fixing this contempt petition. Okay? You will get it listed on this date.
Please, my
My lord, I think that writ appeal number may be noted, my lord, otherwise.
What is the number?
lord. The writ appeal number 826 of 24, my lord.
826 of?
24, 2024.
That's our jurisdiction. Right? We are not connected.
Or sometime next July or August, my lord.
We'll give you a date.
Yep.
Serial number 26, Sidramaya,
Lord, in this case,
Give the date to him.
49.
Next.
Lord, serial number 26, my lord.
Lord, in this next matter, my lord, that can be dropped, my lord.
They have complied?
Next matter we complied. We
That is
complied.
not-
But they have complied?
They have complied.
Mr. Bhatt states that the order of which non-compliance is alleged has been complied with. Dismissed, he wishes to withdraw the contempt petition. Dismissed as withdrawn.
Very grateful. My lord.
Twenty-five is dismissed as withdrawn.
26,
For the appellate in this case, my lord. Lord, I have filed a memo for withdrawal in this case, my lord. The matter has been settled, my lord.
Just shared, then a counsel for the appellant has drawn our attention to a memo for withdrawal of the appeal. The memo reads as an list of the counsel read. In fact, we find that dated 7/4/25, in fact, we find there is another memo filed on 22/1/25. Will be streets as under. Stop. He reiterates the prayer for withdrawing the writ appeals. Writ appeal. Dismiss as withdrawn. Writ appeal is dismissed as withdrawn.
Grateful, my lord.
27,
That's,
serial number
the appellant.
27.
That's I appear for this matter. That's for the respondent number 1, my lords. We undertake to file wakalat on behalf of respondent number 1. My lords, the office objection was that they have not filed any acknowledgement that they've served a copy upon us.
You appear for whom?
Respondent number 1, my lords, a private party, Aditya Ravi Raj. I shall give my name, my lords.
So and so appears for respondent number 1 states that he shall file wakalat
I undertake to file, my lords.
on behalf of the said respondent.
That's
2
one.
and 3, 2 and 3 are represented by so and so.
That's one request, one submission, my lords. The writ appeal, my lords, might have become infructuous. The reason being, my lords, the order passed by the single judge was to reconsider a particular quantum which was awarded to us, having acquired the land for the purpose of putting the high electric lines, my lords. That, my lords, has been reconsidered, and my lords, an order has been passed. May I pass the order before the court?
Just give it to him.
Yes.
That is a separate cause of action, my lords. Because
could be so.
once it has been reconsidered, I am challenging it only purely on the ground saying that you
No,
cannot.
what he's saying, Mr. Samuel,
Yes, sir.
he says insofar as this writ appeal is concerned is become infructuous.
Yes, because the order has been considered.
Having been done.
Yes.
I am not, my learned friend might be partly right. I wouldn't deny that particular fact. But it has to be effaced. The order directing them to consider it based on the present market value on the converted land, my lords, that might be wrong.
No, but this is only with regard to corridor.
Yes, my lords, line corridor. It's regarding line corridor.
With regarding line corridor, no?
Yes, my lords. My lords, I don't have the benefit of the order passed by the DC. If it can be taken up tomorrow, my lords, I'll just look at it.
Based on the order passed by the single judge, my lords, and our final order has come to pass.
Right of way, no? Right of way corridor.
Yes, my lords.
So I think you must look into this. Possibly you may be right also.
Yes, my lords. I'll just look at it, my lords, and I'll just make my submission
Say
tomorrow
that-
itself, my lords. It's a short point.
Yeah, the learned counsel appearing for respondent number 1 states that the present appeal has become infructuous as pursuant to the order passed by this court by the learned single judge on 26 July 24.
That's correct.
The respondents have passed a fresh order on 19/10/24.
Yes, my lords.
Posta, he has given a copy of the same to the learner counsel for the appellant who seeks some time to look into the same and take instructions. Just give it in July end, ma'am.
It's an earlier date, my lords, 30th of this month.
17/7.
Grateful.
28, Shri Hemant Rao.
My lord, serial number 28. My lord, it shows as await notice for respondent number 2. Respondent number 2 is the recovery officer of DRT, my lord. So I request your lordships to dispense, if possible, the notice
also
to
in,
respondent number 2.
Serial number 28.1, I have not received copies of the papers yet. My
I'll
learned friend
serve
could
the
serve
copies.
copies on.
What was the stage against which you filed the writ petition?
My lord, an attachment order came to be passed by the recovery officer. I was not a certificate debtor at all. I was a complete third party. I had.
What was the jurisdiction?
Purportedly under section 28(3) of the Recovery of Debts Due to Banks Act, a order was passed against my registrar and transfer agent to redeem mutual funds that I hold and credited to the account of the appellant here.
Will not the DRT have the jurisdiction?
No, my lords. No, my lords. This is not an appealable order in that sense. This was an order that was, in fact, learned single judge has gone into this. This was an order passed without notice to me, without, in fact, even though.
Other than that, otherwise there is an appeal.
It's an appealable.
It's an appealable order?
Otherwise, it's an appealable order, but my specific case before the single judge was that no notice was issued to me. In fact, the order was set aside on this very ground.
My request would be to condone the delay, my lord. It may be posted for admissions. There are delays.
I'll file my objections 2 weeks, your lordships.
How much is the delay?
96 days in the first appeal. I'll place my objections in.
What will be objection for 96 days?
I'm at your lord.
It's not a so grave a delay.
Please.
This is an application seeking condonation of 98 days delay. Why 2 appeals?
There were 4 separate petitioners, your lordships, and 4 separate orders were passed.
4 separate orders.
Just in all these, all the delay. Otherwise, you will appear for all the respondents?
I appear for the first respondent in the first appeal. In fact, in 28.1, I don't have a copy of the appeal, so therefore I may not be able to.
Recovery officer, we don't think we should issue notice.
No, not required.
My lord, in 1601, I appear for.
In all the appeals, 67 days those delay, na? For the reasons stated in the affidavit. Delay is confirmed.
My lord, a date may be fixed, my lord. They have moved before the act.
List all these appeals for notice to respondent number 2 is dispensed with.
Please wait for
Notice be issued to the list the appeals for hearing on.
Please.
There's only 2 respondents in all the appeals.
Yes.
In
the second one.
In 1601, your lordships, there are 2 respondents. I think in 1609, there are 3. In 1609, I appear for the respondent number 1.
Yes.
See, you have to be clear on this.
Yes, ma'am.
Now, who appears for 3, 4, 5?
28.1.
And service effective 3, 4, 5.
No, sir.
Let notice be issued to unserved respondents, if any, in all these appeals.
Yes.
Returnable on, except the recovery officer DRT, except the recovery officer 1, DRT tribunal 2.
Please. And copies may be served in 28.1, your lordships, because last time also I had made this request to my learned friend.
I'll serve the
28.1 copies have not been served.
Immediately.
You should serve him a copy, otherwise what is this?
I'll immediately serve.
Let the copy of the appeal paper book be given in all the appeals to the counsel appearing for the respondents number 1 within 1 week.
Yes, ma'am.
8, 9.
Great.
Serial number 29, Shri Chandrakant Gowla.
For the appellant, my lords, a week's time will take fresh steps, my lords.
Notice to R3.
Eight, nine. Serial number 30.
My lord, it's a state appeal, my lord, a week's time to.
Thirty.
30, my lord, state appeal, my lord, a week's time for compliance, my lord. Service is yet to be completed.
Notice to R1.
Please.
8, 9.
R1 and R2.
31, serial number 31.
Notice to respondent.
Lord, I'll pay the process today by the end of
Actionable
the-
on.
9, 9.
Wait for-
32. Serial number 32.
Office objection
In
be
this
clear.
case. For some time to file objection, comply the office objects.
Office objection be complied with in 4 weeks.
But, in this case, that it is the land which was purchased by the ex-servicemen. That in the year 1988-89. That challenging that after 14 years, he filed an appeal before the assistant commissioner saying that he is in unauthorized occupation of this land and he want regularization. His application filed in 2000 is pending. The AC without notice to us allowed that appeal. Against that, we preferred appeal revision petition to DC. DC set aside. KT also confirmed that order before the High Court. High Court also held that as I have purchased this land in public action, the question of regularization would not arise. And the case what they have claimed is it is a privilege case. And the writ petition was dismissed. After dismissal of the writ petition, they filed a suit before Gauribidnur court saying that they have perfected this land by way of adverse possession as they are in possession of this land adverse to my interest. This is the claim. Two dual stand that has been taken. So their case on its face is
Him clear the office objection because there is a deficit court fee also.
Yes, he'll comply.
He let him comply with that.
Let him take notice, if it is the notice not yet ordered.
We'll just say that the office objection of non-payment of the deficit court fee is not complied with in 2 weeks' time. Okay, the appeal shall be dismissed without.
Actually, I'm 400 rupees I need not pay, because based on the applications filed by them, that is the challenge. I will explain, but into the office, I will cure the defects.
Without reference to the court.
I will cure the defects.
Earlier also 2 weeks time has been granted, that has not.
We have served on preemptory order. If you don't do it, it will be dismissed.
Much.
33.
Petitioner. Office objection on annexed L maybe.
We have to show the file.
Office objection.
Office objection be cleared within 6 weeks.
Lord, it may be overruled annexed L. It is a report, my lord. They are seeking color print of that photo, my lord. Report given in the black, my lord, therefore black and white. Therefore, office.
You clear the office objections. Next.
6 weeks. 4.
You have to say 3 weeks. Say 3 weeks.
1, 9. Serial number 34.
Appeal for the petitioner, my lords. Small issue, my lords may just see in this PIL at page 24, our prayers are very limited. My lords, there is a park in Indranagar, which has been declared as a park by another order of this honorable court. We are only asking at page 24, either BDA maintains it as a park or it hands it over to BBMP to maintain it as a park. Right now, my lords may see from page 64 on 63 onwards the photos. It is left as a park, but nobody can use it. Trees are overgrown. It has become a
What do you
dumping
say?
ground.
You appear for whom?
Respondent number 2.
2 is BBMP.
BBMP.
In fact, from 14, it has come that despite asking them to file reply, they haven't filed.
Show us the last order sheet.
In fact,
Who
on
appear for BDA?
it's for BDA, my lords, not government.
No, the government is not there.
Government
BBMP
is
and
not there.
BDA.
BDA and BBMP. In fact, on
Just say that
orders were passed on 14/2 to file a reply. And reply to be filed within 10 days.
what do you say?
My lords, regarding the reply, we'll file it within a week, my lords. But the most of the prayer is that towards the BDA, my lords. Either if they hand it over, will they seek instructions from my client?
Mr. Sachin appears for it.
In fact, BDA has stated in an order, if I can just show, my lords, there's an order of this honorable court at page 58. At page 58, the order starts, it's a 5th January order. Relevant.
Find no appearance for the BDA. This is the second round of litigation. The association having earlier filed writ petition 2263 of 2011.
Yes. At page 60, at page 6.
Was regarding the cancellation of lease.
No, that was not filed by me. That was filed by another association which had been given a lease. That was terminated, and in that order, at page 60, at the bottom of the page. Yes. It is a second round because another organization which was given the lease, they didn't carry out the
What
term.
is the Social Welfare Trust?
Yes, that was the organization that had filed. We are a different petitioner. We are a residents group.
Just say none for the respondent number 1. Full stop. Time is time of 3 weeks is granted to file the counter affidavit to this petition. Okay. Liberty shall be with the respondent number 2 to file counter affidavit.
Some July date, my lords. Finally.
File counter affidavit if so desired. Full stop. Re-notify. I'll just give it in.
24/7.
Great.
Next.
Serial number 35, Shri Balraj.
Petitioners, the respondent number 7 died. Take necessary steps in respect of the deceased respondent number 7, my lord.
What do you say?
Yes, please.
I had to file my objections, my lord, in respect of respondent number 3 and
Only
5.
for
Here for whom?
Respondent number 3 and 5.
3 and 3 to 7.
No, my lord. They are different.
No, you appear for 3.
Yes.
Then?
And 5, my lord.
3 and 5. What about the others?
Others served, my lord, but except respondent number 7. The respondent number 7 died, the poor college says.
7 died. Okay.
It's a limited prayer, my lord.
Just say that.
The only for writ of mandamus regarding the encroachment of.
Yeah.
What do you say?
Some malefides are there, my lord, on part of the initiating the proceedings. And my lord, the alternative remedy is there under the Land Grabbing Act. I'll place it, my lord, 1 week.
Just say that counsel for respondent number 3 and 5 seeks and is allowed 4 weeks to file counter affidavit. Respondent 4 and 6, those served, are not represented. We have been informed that respondent number 7 has expired.
Yes.
Stop. Counsel, what do you want?
I'll take necessary steps.
The counsel for the petitioner states he will take.
Submission,
He
madam.
will take.
Only,
He will take necessary steps in that regard.
can I make one submission, my lord? The matter pertains to PIL, my lord.
Any day, my lord.
Yes.
The respondent number 7, the matter pertains to PIL, my lord. It's only for writ of mandamus against the government. So need not be required, my lord, the respondent number 7, my lord.
No, he wants.
Only
to
for
say
limited prayer. Let the Tahsildar consider.
He has an objection on the alternative remedy.
Yes, I'll place it, my lord, within 1 week.
Next.
19, 36.
My lords, I am for the appellant. I am filing a memo for the another address of the respondent. Notice will be issued to the both the addresses, my lord, and also hand summons apart from the regular notice, my lord, because they are there only but not receiving.
Notice to respondent number 1. Written, including hand summons, returnable on. Notice to respondent number 2 is dispensed.
Both the addresses, my lord, kindly. Memo for address also filed for fresh address, my lord.
Pardon?
I have filed a memo for fresh address also for both the addresses, my lord.
Okay. Notice to respondent number 1 on the address in the memo parties and also on the fresh address as submitted by the counsel for the appellant with a memo. Where is the memo? This memo here. And also on the fresh address, just say that.
Yes, yes, my lord.
Fresh address as furnished through memo.
Yes, my lord.
Filed today in the court, which is taken on record.
Yes, much obliged.
49. Serial number 37.
Complaint.
First page only.
I will check it up, my lord. I will. There's been a positive release of.
So what do you want?
I will check it up, my lord.
They want to confirm and make a statement.
One date.
What have you given to him?
Now I have.
Arrears of pay scale had to be given to them. So I've given the statement which is reflecting that we have released the
Say at
payment.
the request of the counsel for the petitioner adjourned to.
39.
Please.
38. Srinivas.
Lord, we have filed a writ of mandamus. my lord.
A1 is the answering respondent, my lords. They have the panel counsel, one Mr. S.V. Giri Kumar had appeared for A1 in the writ.
What do you say? Anything remaining?
My lord, they have not given any reply. my lord.
Hmm?
They have not considered our representation. my lord. Auto has been served, my lord.
R1 served. No?
Sir, our own service.
Despite service, there is no appearance for R1. Let R1 be present in the court on the next date of hearing. Copy of the order be sent
R1 answer.
to R1 for compliance.
R1
29.
response. So, next date.
39.
I'm withdrawing the petition, my lord, since it became infructuous. I'm withdrawing it. Since it became infructuous, my lord, I'm withdrawing it. That the petition may be dismissed or withdrawn.
You want to withdraw this? This 39?
Yes,
Then the counsel for the appellant has filed a memo for withdrawal. The memo for withdrawal just say that though dated 10/3/25, he reiterates the prayer for withdrawing the appeal. Full stop. Accordingly, the appeal is dismissed as withdrawn.
Forty,
For the complainant. Though it's in the stage of issuing notice, we have complied, my lords. Change of kata.
Malas, it's still in the name of Venkatramanappa, who is the original grantee, Malas. I am the son, Malas, Taddana. I will verify with my client, Malas.
The Mr. Chandrasekhar said the order has been complied with. Full stop. Then a counsel for the petitioner seeks time to take instructions.
T9. 41 adjourned. 42.
My lord, a writ petition, my lord, was filed by me insofar as seeking direction, my lord, against the respondents to release an amount of 65 lakhs, my lord, in accordance with the arbitral award passed under 3(5)G, my lord. 3G5 rather. Lord, this writ petition was allowed. Thereafterwards, necessary directions, my lord, were given. Kindly see in page 17, relevant page, my lord, is 21.
Has it been heard, Mr. Ramesh?
My lord, what happens is maintainability is the one which has been raised.
Maintainability, overlook it.
Please, my lord.
We will know that. We will overrule it.
And there is one more objection saying
You
that
have a huge delay.
no delay, my lord.
You are not a party.
I am the writ petitioner.
You were there.
My lord, my writ petition was modified by virtue of this review petition. Now, consequently, my lord, review petition on the date of the orders passed in the review petition, my lord, it is within time. So there is no delay.
Writ, there is a delay. For the writ, there is a delay.
My lord, writ is allowed in my favor.
That's right. Who was the review petitioner?
Review petitioner was the respondents. I never challenged it.
Which respondent?
My lord, respondents 1 to 4, 1, 2, and 4, as well as 5. This was a review petition filed by the respondents. And in the review petition, my lord, the entire order, my lord, is modified to the extent of the.
But no notice to you.
I was issued notice. Thereafterwards, my lord, after hearing both the parties, my lord, the review petition was allowed or disposed of, reducing the extent of land. Total extent of land acquired from me.
Just say issue notice. We will all deal with all the objections.
Please.
Issue notice on the appeal and as well as IAS. In the meantime, office objections shall be complied with.
Lord, all the office objections have been
There are
complied.
4 office objections.
I have given my submissions. They only say that, my lord, non-readable copies have been filed. All the it is readable, my lord. That is what is the submission.
No. We will go by their perspective.
Please, my lord. I'll just, anyways, I have given my submissions also to that effect. That it is.
To file it, make it a better type copy.
Very well, very well. I'll just go through.
8-9.
Please.
43, serial number 40.
Lord, insofar as the objection regarding maintainability, my lord.
Look into it, not an issue.
Please.
Maintainability. Just say that. Where is it? It's gone. 43.
Appear for the appellant. My lords.
Just show the file. Yes. Now you say that the new regulations are not applicable.
Lords, it is applicable, my lords. The appellant is a physically handicapped person, my lords. Two prayers were sought for. One is for revaluation. Now, as per the new regulation, that is held commonly, that is not under challenge now, lords. The other one was, because he is physically handicapped, he is having a infirmity in his hand, my lords. He sought for an opportunity to rewrite the examination with the help of a scribe, my lords. That prayer has not been considered by the learned single judge.
But when did you apply for? Did you apply for scribe?
My lords, if your lordship.
Are there any instructions for taking the assistance of the scribe in the examination procedure?
My lords, the Supreme Court has laid down the guidelines.
The cause is then when the exam was to be written.
My lords.
You should have approached. Did you approach the learned single judge then?
My
Or
lords.
after the examination?
My lords, after the examination, yes.
The point, Mr. Gowda.
Yes, please.
Otherwise, and were there any instructions for giving the assistance of the scribe in the examination process?
My lords,
That's the time when you will say, yes, give me.
my lords,
And there is a procedure laid down. You have to get the doctor's certificate,
that-
everything. And
tho-
all
tho-
those
those things are now taken, my lords, and produced before my lords. My lords, and on equity, my lords, if your lordship kindly
things.
consider.
Hey, after having.
I definitely understand, my lords. Those procedure, there is some infirmity in following those procedures. But before this honorable court, there is a certificate from the government district surgeon showing that he is having this infirmity. He cannot write the exam in the required time limit. That is there.
You may be right. You're right.
Lords,
And person is
there-
entitled to.
Therefore, my lords, now, my lords, if your lordship is pleased to issue notice, my lords. Presently, they have not called for the main exam also. Because, my lords, if he is, my lords, he is a case, here is a case, my lords, where he is physically handicapped, my lords. And I totally understand, my lords. I totally understand. He is a student. Your lordship may kindly show some mercy on this student. That is the humble request, my lords.
Now, what is the exam is for the post graduation?
No, graduation, my lords. Graduation.
This is under this thing, under issued by the National Medical Commission, NMC.
Yes.
There were 3 petitioners.
3 petitioners were there. The other 2 petitioners, my lords, they have not challenged. Only because this person on a special ground.
What is the infirmity he has? The handicap?
He is having an infirmity in his hand, my lords, writing hand. He has suffered a
He can't
paralytic.
write.
My lords.
He can't write.
He can't write with pace, my lords. He
With
can.
the speed.
Yes.
And now what is the ensuing examination? What is the examination coming?
My lords, this is the first year MBBS course examination. That is the ensuing examination.
Now you could not clear the first year.
Only if I can clear the first year, I can go to the next year. Or else this is end of his career as so far as MBBS is concerned.
Just say issue notice. Returnable on.
19.8.
Grateful, my lords. Deeply obliged.
Next.
44.
My lord, on this honorable court on 6th had directed the commercial court to pass orders by the 20th. They have sought for an extension. It's adjourned to tomorrow, my lord.
We see there is a letter. How much is the delay? It need to be extended.
Please, my lord.
Make sure the letter. So you have submitted your arguments.
Submitted, my lord, within the timelines prescribed by your
Has
lordships.
reserved the orders.
On the 13th, my lord, as was directed. In fact, my lord, the learned trial court has posted it to tomorrow for passing orders.
Just say this we have disposed of this commercial appeals on 6th June 2025 by stating in paragraph 4 as under. First of the Registrar General, Learned Registrar General of this court is in receipt of letter dated 18/6/25 from the office of the City Civil Court, Bangalore, wherein the following has been stated. First up, in view of and we have been informed that the date for pronouncement by the date for pronouncement upon hearing in terms of our order has been fixed as 24th of June 2025. If that be so, we extend the time for the trial court to pass the order till 24/6/25.
Great.
Complainants in this matter. Lord, I may be permitted to file memo for withdrawal of the complaint. Since the orders passed by the learned single judge have been complied by response to entry and appointment orders have been given to all the complainants.
Learned counsel for the petitioner, complainant has filed a memo for withdrawal. Has filed a memo which reads as under. Complainants, reads as under. The learned counsel for the complainants reiterates the prayer for withdrawing the appeal. Withdrawing the contempt petition. Accordingly, the contempt petition is dismissed as withdrawn.
Sanjay Yadav.
For the accused in this case, your lordship, a short accommodation to be given where we will filing the statement of objection regarding to this case, your lordship.
There's no one for petitioner. None for the petitioner. Request of counsel for the respondent to want to file compliance affidavit or reply affidavit?
For the main petition, we will be filing the objection.
File reply affidavit. This is a contempt now.
That we have not defreezed the account. Sir.
No, you appear for whom?
Accused.
Okay. Reply affidavit.
4/9.
Great.
I appear for the appellant lord. Lord, the respondent has initiated proceedings for recovery against the appellant. Appellant is only a business correspondent agent. His job is to bring the person's borrowers to the bank, for which he is given some commission. He is not a borrower, so he is not called as a business correspondent agent. He brings he's a link between the borrowers and the bank. We have entered into an agreement. The bank says that I have to deposit, I have to take care of 10% of the loans in case it becomes NPA. That agreement is there. Now the entire loan liability, they initiate proceedings against me for the amount not paid by the borrower, which I cannot be proceeded against, my lord, because Kindly see the agreement, my lord, business correspondent agreement. Page 55. It does not come within the definition of the borrower at all.
How much commission he was getting
But
otherwise?
they gave me about 6% commission,
Huh.
and there is one more clause in the agreement saying that in case amount is not paid, I have to reimburse them 10% of the total loans. So my liability, in fact, at page 64 of the agreement, except this, I am asked to furnish security for the loans disbursed, and business correspondent shall provide 10% of the total loan disbursed or outstanding in the form of collateral security. Apart from that, at page 65, if the amount is paid, then they will give me 6.5% commission. This is in accordance with the RBI circular, which I also have produced. Now let us take everything against me. My liability is limited to about 10% of what amount is not paid. Now they are trying to fasten the entire liability of 24 crores on me. Let us save a lot, because every day I am bringing creditors. Even now I have been getting creditors to make the payment. About 75 lakhs to 1 crore, I am getting it paid to them. Now let us assume entire thing against me. This out of this 20.
He is not a surety.
I am not a surety, I am not a borrower, I am not a guarantor. And where is the question of 13-2 notice? I file my objection. They don't even answer me.
But how would you answer paragraph 4?
Paragraph 4, blood. The writ
Of the order.
Yes, blood. That filing going there, entire the authority itself is without jurisdiction. If I go to DRT, blood, they will ask me to pay 20%, 30% of the amount demanded, for which I am not liable to pay. Now the entire proceedings are without jurisdiction. A single judge does not consider the issue on merits at all. Now, if it is a case of a borrower and I default in making payment, this entire act itself does not apply to me, because the definition of borrower is clearly there. In fact, borrower says
No, there is a judgment.
Definition of borrower.
See, there is a judgment under the RDDB Act, I think to my recollection, that pre-deposit is only confined to only particular, one is the person who has borrowed it and not to a third party. Previously interpretation was anyone who is coming here, he has to make a pre-deposit. Possibly a similar argument what you are now advancing. Someone who is not connected as a surety or as a borrower, can he be fastened with the liability or to make a pre-deposit before he can invoke the jurisdiction also?
Yes. Let the definition of borrower also, who has been granted financial assistance. I am not the one who is granted financial assistance. I file my objection to 13(2) notice. Then I also don't receive the order also. No order, I have not received any order under 13(4) which which entitles me to go further. Objection is not considered. Straight away they issue a possession notice.
You appear for whom?
I appear for the bank, my lord.
What do you say?
My lord, in this case, my lord, as a security, third party has executed the mortgage deed. That
Who has executed?
third party, that at their instance, third party that offered security for the loan. Your lordship may kindly see that one, the mortgage deed, what they have mentioned. That in consideration of the bank, sanctioning the credit facilities.
Which page you are reading?
No, my lord, is there. I think
No, it
not
is
produced.
there, my lord.
I'll produce, my lord.
Lord, I have
Just
produced the mortgage deed itself.
mortgage deed.
My lord, kindly see page 64, security.
At that time, I'll just read, my lord.
It
This
is
is
part of the
exactly,
agreement itself.
by doing so, that security interest has already been created in respect to the loan. I read that, my lord. That
Now,
that in consideration of the bank sanctioning the credit facilities
It is there.
to the borrowers here in before referred and on their request, the depositor, that means by the mortgager, herein confirms having deposited to the bank at its branch at Channagiri branch on 25/8/2022 the documents of title deed in first schedule here too relating to properties of the depositor and the
Which page, which clause?
Page 93, my lord, is the mortgage deed.
Page number in the mortgage deed is 3, my lord. In the
Mortgaged it.
I have mortgaged, my lord, 2 properties coming to about
Your own properties.
my own properties, because the agreement says at page 64, my lord, may kindly be seen. 64, security. Only 3.5 crores is the value of the security at page 64, clause 20, security.
Yes.
Security, the business correspondent shall provide 10% of the total loans disbursed or outstanding in the form of liquid or collateral security. This security is based on the loan leads submitted to the bank. So this is the pursuant to this, these 2 securities have been given, which comes to about 3.5 crores. This 10%, the maximum, Lord, they can fasten the liability on me to the extent of 10%. But the question, now the issue notice, kindly see, my lord, for entire loan liability, they seek to fasten on me. Kindly see page.
So in a way, you are a guarantor.
I'm only assured for this amount. This amount I'm ready to deposit.
I think he is right, learn a signature. Then you must go to DRT.
No, my lord, so far this 10% is concerned, I'm prepared to deposit it before the court.
But you will go to DRT, not like
No, but this is not a guarantor, my lord. This is a security for this loan transaction. According that also doesn't make me a borrower because I avail the financial benefit.
But may not be a borrower. Surely a guarantor or a surety.
No, not a guarantor, my lord, because it is not a guarantor in respect of the total amount. I am guarantor for 10% of the amount. For that 10%, they can entitle to recover. But to say, kindly see, my lord, at page 32, entire loan amount is sought to be fastened on me. For that, my lord, there are no jurisdiction. This 10.
I don't think we should interfere in this.
Blood, there are two submissions, blood. One is, under this is an independent agreement for which there is an arbitration clause. Now, they have any dispute with regard to this, they are entitled to initiate arbitration proceeding. Now, in so far as beyond this 10%, my liability is not there. I am saying that so far as fasten the liability of 10% on me, to say that the entire loan amount is to be fastened on me, blood, is one without jurisdiction. Now they are calling upon me to meet 24 crores 48 lakhs, which is disbursed to the borrowers, and they are every day recovering that money. I'll be put to great difficulty, Lord, which I'm prepared to deposit, let us say 24 crores, Lord. This 2.4 crores, I will deposit the money before this court or pay it to them.
The only thing is what has been said by the learned judge is right. 3 and 4 SARFAESI Act we will invoke. Otherwise, we are creating confusion. One here, one there. The scheme of facts, statutory provisions are there, you will invoke it. And this ground would be available to him, to you, before the DRT. You will argue it.
Only
That's
thing
where
is,
now the Supreme Court has very said, ultimately anything which is concerning DRT must be before DRT.
no, that's true, my Lord.
We
That is
thought,
why
initially we thought that you are neither the guarantor nor the borrower.
no, this is given only as a security for the loans given to others. This loan, my Lord, is confined to 10%. Beyond that, they cannot claim any money at all. The question, so far as the issue, my Lord, with whether they can demand beyond 10%, Lord, there again, I will be called upon to deposit on this 24 crores. my Lord.
You may argue there. You may have a remedy if they insist upon possibility to come back. But at this stage, threshold, so you must go DRT,
Lord,
put your
this-
case. If they deny it, come back.
Lord, this 13-2 order has been issued, or the notice is issued, for which I have filed objection. Mardia Chemical says, thereafter they are required to pass a 13-4 order, against which I will have to go to the DRT. There is no 13-4 order at all.
13-4 order has already been passed, my lord.
They have not communicated it to
And
me.
19-6 it has already been passed.
They have not.
Not in this fact, Mr. Ashwin.
19-6 has already passed, my lord.
Not in this.
13-4 order, they should at least supply it to me, my Lord.
You give it to him.
They have not given it to me. And it is not communicated to us at all till now. And they straight away come and take symbolic possession of the property. This is possession notice, my Lord.
13-4.
Where is 13-4?
13-4 is.
This is taking possession notice.
That is under 13-4 only, sir. Possession notice is under 13-4 only.
No, there is no consider.
This is
This
13-4 notice
possession,
only.
my Lord, they have issued a possession notice. No, my objection is not considered at all.
Possession notice is
Straight away they
13-4.
have issued possession notice.
That would be the remedy for you to challenge. That would be the.
Yes,
But
my lord,
this is a
exactly.
clearly high-handed action, my Lord.
But now, insofar as the learned single judge has said, I don't think we should really. And that's the position of law.
No, but only one exception which I would request the court to consider is, beyond this 10% blood, this the demand is one without jurisdiction is my.
You're right, but you will still urge before the DRT. Let the DRT apply its mind on this. You may be right on saying so also. Even in any case, in terms of the deed also, my liability can't exceed this much. And how can they do it? Awesome.
May I at least request, my Lord, one thing. Your Lordship, at least DRT to consider this submission, my Lord. Otherwise, they will mechanically order pre-deposit of the money. This contention, at least let the DRT consider it.
We can only say, we'll record your submission. You want to withdraw it, approach DRT.
Only thing is one additional.
And to take all pleas available both on facts and in law.
No, but with regard to this, my Lord, only one additional observation is, let the DRT consider my submission. I am not saying it should be allowed.
You are right. You are right. But there cannot be anything that they will not consider it. You will urge that point and let them. That's the reason we say you urge. If they reject it, possibly you have a remedy. Because the remedy would be from DRT.
Again,
Without approaching DRT, there would not be any remedy today. Want to withdraw this?
Lord, at least your Lordship may direct DRT to consider this submission.
It doesn't really require it. We will record your submission. We'll record that. Just say that the challenge in this appeal is to an order dated so and so, passed by the learned single judge in writ petition 12557 of 2025. whereby the learned single judge has in paragraph 3 to 5, 3 to 6 has stated as under. After some submission, learned senior counsel for the appellant seeks to withdraw the appeal to enable the appellant approach the debt recovery tribunal, debt recovery tribunal by and in order to urge all the pleas available to the appellant, both in facts and on law. Okay.
Lord, they have already issued a possession notice. Let them not precipitate at least for 2 weeks, within which I will approach.
What do you say?
Yes, my lord. If that is the case, 2 weeks we'll wait, my lord.
You will say so. We'll record your this thing.
This I have not found out for the bank, my lord. But anyway, that possession notice is issued on 19/6. Still there is time 30 days for sale notice.
Which is the order you would challenge?
They have, my lord, initially I have challenged 13(2). Now, before I could file the writ appeal, they have issued a possession notice pasted on the building that symbolic possession is taken. That is why they should not resort to 14 and throw us out of our
My
building.
lord, but after possession notice, my lord, that 30 days time is to issue sale notice. That is as per
You
Surface
issue
Act.
possession notice.
19/6.
13/6. So you have 30 days.
No, that, my lord, again depends upon their whims and fancies. They can do
30 days
anything
you cannot,
beyond
it is
that.
mandatory provision under
If
Surface
they say
Act.
30 days, they won't do anything, my lord, that could be recorded. They will.
But in any case, possession notice given, it goes without saying 30 days are still there for taking possession.
No, but the notice, my lord, notice.
But they can take it before that also.
Yes,
They can take
that
it
is
before
right.
that also possession.
Possession, symbolic possession has been taken, my lord.
That's
Then
right.
next stage is to issue sale notice. That is 30 days is mandatory, we have to wait.
No,
For
but
which notice?
Sale notice, sale.
Sale notice.
That is after 30 days. Before 30 days, they can approach and get whatever the order.
I think then you must approach the DRT at the
No,
earliest.
we will approach, my lord. The notice doesn't say anything. 30 days does not say it. They
But
say
that is the
immediately.
Surface Act, my lord.
Provisions of the Surface Act.
It is
No,
there, my
but
lord.
the
Provision
entire
of
thing
Surface
is
Act.
on the assumption that they will behave in accordance with law. In my case, my lord, it is not so. So that is why my apprehension that they will further precipitate the matter. Give me some
Precipitate in what sense?
precipitate. They have already come and pasted notice, despite my saying that writ appeal is filed, it is coming up today.
That in any case, that's basically with regard to the having taken the symbolic possession after that order.
Yes, after that order.
Now, within 30 days, they would be going ahead with the sale notice.
Sale notice, yes, my lord.
Now, 30 days from which date?
From 19/6.
19th of?
19th of June, they issued the possession.
Relevance of 19 June?
That date of possession notice. On the day they have taken symbolic
19 June you
possession.
have till 19/7.
The lordship may kindly note that, my lord. That is.
We will only say this, okay, just say this at this
But
stage.
it is
Learned
mandatory
Counsel-
provision, my lord. 30 days you have to
No, we
wait.
are only recording your submission. At this stage, Learned Counsel for the respondent number 1 bank states that the symbolic possession has been taken. And what do you issue on 19/6?
Symbolic possession, 19/6.
Huh.
Symbolic possession has been taken.
It just state that
Symbolic possession of the mortgage properties.
symbolic possession of the mortgage property has been taken on 19/6/2025.
Yes, ma'am.
So he also states that the appellant has, the respondent bank has to issue notice for sale within 30 days from 19/6/25.
Yes, my lord.
That's right? Dismiss, say that dismiss as withdrawn. Next.
In that day, they shall not precipitate at least before 30
So
days.
that's why reason we
Oh, my
have,
lord.
no, that's
It will
the
not.
reason we have noted his submission. You have 30 days from 19/6.
After 30 days, my lord, within 30 days, I think your lordship's recorded. After 30 days.
From 19/6.
Sale notice can be issued after.
After 30 days. Are we right?
Yes, my lord.
After 30 days.
After 19/7.
Okay, just say, don't say within, after 30 days.
Yes, my lord.
Of the issuance of the possession notice.
Possession notice, they have to issue sale notice.
Okay. Next.
C8.
My lord, I appear for the petitioner. It's a public interest litigation. The Sadashivanagar resident, please, my lord.
Yes.
The Sadashivanagar Residents Welfare Association, my lord.
Yes, who appears? What are your instructions, ma'am? This was mentioned before us. What happened on Friday?
Friday, my lord, this court was not sitting and then moved the other court. My
What
lord.
are your instructions on all these things, ma'am? Is it within permissible or beyond permissible limit? Permissible. What is your case?
My lord, my case is that the Karnataka Excise General Condition Rules 1967, Rule 5 says that.
What is the distance?
100 meters is the distance.
From which place?
From the temple compound to the shop, my lord, or the bar.
100 meters.
100 meters.
Within
my lord.
100 meters, it should not be there.
Yes, my lord.
Beyond 100 meters, permissible.
Permissible. I have no objection, my lord. If it is beyond 100 meters, let them carry on. But here it is just next door, virtually one road across, my lord. Hardly 30 to 40 meters.
So from the outer limit of the temple, you will measure the 100 meters.
Please, ma'am.
From the middle of the
The entrance of the license premises.
My lord,
you do one thing, file your affidavit.
Let them file an affidavit saying that.
You just file an affidavit, put it on record. Just say that who all are appearing for the parties? Notice, say 1, 2, you appear for 1 and 2.
Then 7.
6 also? So this is for the Government of India?
Yes, ma'am. For the time being, it may be dispensed with.
Okay. Yeah, it's Government of India. 1, 2, 5, 7. Yeah, right. 1 and 2 and 5.
And then 7. 8 and 9.
8 you would not be, ma'am. 8 would be,
Safety and standard of.
this would be under the Government of India.
No, Malad, we also have a branch. 9.
Okay, just say 1, 2, 5, 7, 9. And who appears for BBMP and Sewerage Board?
Malad, they have the standing count.
Issue, just say that, issue notice to 3, 4. And 3, 4. Your only grievance is with regard to bar?
Bar and also, my lord, the commencement of a restaurant within the residential area, my lord, is also not permitted according to me. Therefore, I have made BBMP also party.
Whose instructions or provisions governs that?
The BBMP, my lord. BBMP, my lord.
BBMP. Okay. How is 7 and 8 are concerned?
My lord,
7 and 8
they
will
also
not really come into play.
Please, my lord. They also have to take permission under the fire safety
Fire safety.
Karnataka Fire Force Act also, my lord, necessary permission is required to start a bar and restaurant, my lord. But for the time being, it may be dispensed with, my lord.
We are dispensing with 5, 6 and 8.
Please, my lord.
Okay.
Please, my lord.
And 9 Chiaku, 10. So notice shall be issued to 3, 4 and 10. Returnable on. Just give it after 2 weeks. In the meantime, the affidavit shall be filed by the councils, by the respondent number 1, 2, 5, 1, 2, 5, 9. 1, 2, 5 and 9.
Along may I make one submission?
And 7 and 9. 7 and 9. 1, 2, 5, 7 and 9.
Along the concerned Deputy Commissioner of Excise is not made a party. He's the one who has this benefit.
This would be under excise.
The Commissioner Excise has made a party, my lord.
The Commissioner Excise, the head of the department is there, man. No. Let the Commissioner file it. Obviously, ma'am, the head of the department is there.
But the concerned
Doesn't make any difference, man. It doesn't make any difference. Yes, within, just before that, just have it after 2 weeks.
9/7,
Next.
Much obliged.
49,
I appearing for petitioner in this matter, my lordship.
Your lordship has fixed a date.
9/7, 9/7. 49,
I appearing for petitioner in this matter, my lordship.
We
My
have
lordship,
filed a memo, my lord.
I
The
made
request
an
in the,
Yes, sir. Yes.
I made an application, my lordship, for for seeking this honorable court indulgence, my lordship, to raise additional grounds and facts, my lordship. And also I have
my
produced
lord, the
some.
request in the writ petition, my lord, was for considering their application for query license.
My lordship,
We
kindly
have
see, my
considered
lordship.
that and issued an endorsement
I
on
will argue, my lordship.
29th November 24, rejecting the request, my lord. Now he has filed an application wanting to place certain facts and grounds, my lord. It is not even an application for amendment of the writ petition. Against the endorsement issued by us, my lord, there is an alternative remedy of revision, my lord, under Rule 53.
My lordship, my application goes to the roots of the officials, my lordship. Kindly see the photographs I have produced along with my application, my lordship. Kindly see, my lordship, application dated 18/2/2025. 18/2/2025, my
Challenge the
lordship.
new endorsement.
My lordship, that endorsement itself is questioned by way of application, my lordship, for which he has taken the time for
So
filing
why
that
don't you file a
application.
fresh petition rather than, why don't you file a fresh petition
My
incorporating
lordship,
all
kindly
grounds?
see, my lordship, kindly see, my lordship, they are encouraging the illegal quarrying. I have produced the photographs. My lordship, day by day, my lordship, they are looting the state's property, my lordship. Because, my lordship, they are looting. Kindly see the photographs, my lordship. My lordship, kindly see the IA 1 of 25, wherein, my lordship, I have produced the documents and photographs. Day by day, they are looting the natural resource. Without granting lease to me, my lordship, they are encouraging the illegal quarrying. Every day they are looting, my lordship.
My lord, they are converting the scope of the writ petition into a public interest
File a
litigation.
reply.
Please, my lord, the
It is
application
not a public
is not
interest,
even
my
in the
lordship.
form of an amendment application, my lord. They want to place certain facts before the court. If they had sought for amendment of the writ petition, my lord, then we could have responded by filing statement of objection. The prayer in the original writ petition is only to consider their application for grant of query license, which has been done.
My lordship, which has been
Lordship, look at the
rejected
prayer,
on
my
the
lord.
ground that, my lordship, this property, this land has been reserved for some other purpose.
You're
My
not
lordship, kindly-
understanding. Just 1 minute, please.
Yes,
What we are saying is, why don't you file a fresh petition incorporating everything what
my
you
lordship,
intend to say?
this is the third round of litigation, my lordship. Earlier, my client has filed two other writ petitions,
IA
my
1 of
lordship.
25, reply be filed within 4 weeks, rejoinder 2 weeks.
Please.
Notice, just say notice. IA 2 of 25, 2 of 25.
49,
Next.
serial number
Some
50,
short date may kindly be, my lordship.
For the
Just give it in
petitioner in this
August,
matter.
ma'am. Just give it in August.
20th August,
Next.
My lords, I request for a pass-over in this matter. We filed an IA for stay. We may kindly be heard, my lord.
My lord, in this matter, my lord, my statement is ready and my objections are also ready. Not, but the officer who has to swear to this has not come. My lord, I'll serve a copy on the petitioner's counsel. I'll serve a copy on the petitioner's counsel. And I'm sorry, my lord, I didn't see my.
It's all right. Yes.
Let's require a short accommodation.
No, but you should serve them. In
Yeah,
fact, we
we will
expect that reply would be.
To my lord, otherwise I would have, the officer has not come.
Just give her a copy.
My lord, I'll do that.
We'll have it, next week we'll have it.
Please, please.
My lords, the urgency is that there's an endorsement issued to stop mining operations, my lord. And this deemed extension of
Just
forest
1 minute.
clearance is applicable.
And PASO is difficult.
Please, my lord, at least tomorrow, my lord.
Just say, just give a copy.
My lord, they are not entitled for it, my lord.
Give a copy, we will hear you. Please, copy of the
My lord, I'll
reply
have to
to.
take an endorsement. I will, my lord, I'll have to take an endorsement. I will do that during the.
We'll just say that learned, the additional advocate general states that the reply to the application 2 of 25 shall be.
Petition, main itself.
And as a endorse, and to the.
Main petition.
To the petition oblique for the stay application. Shall be filed within 2 days. She says that the advance copy of the same shall be served on the counsel for the petitioner during the course of the day.
Yes.
Okay. Just say re-notify and just give Thursday or Friday.
Please, my lord.
27/6.
Please see the date, man.
27/6.
Right. Why is it just next?
51. Satish.
Yes.
I appear for the appellant. Lord, the present writ appeal is filed. Lord, only the challenging the portion of the order, not where, Lord, direction is issued to pay, Lord, cost of rupees 10 lakhs on the, Lord, present appellant. Lord, the appellant was the respondent number 4 before the, Lord, Honorable Learned Single Judge on his official capacity as, my Lord, Special Land Acquisition Officer. Lord, the land belonging to, my Lord, the private respondent was subject matter of acquisition. Lord, it was acquired for the purpose of, my Lord, national highways. Lord, the appellant being a, my Lord, Special Land Acquisition Officer, Lord, has passed an award in respect of, my Lord, petitioner before the Learned Single Judge is concerned, my Lord. No documents were, my Lord, furnished, Lord, pertaining to the title. Lord, I have deposited before the civil court. I have not dispersed the disputed portion, but that is deposited before the, Lord.
What is your grievance against this order?
Lord, at para 43 and 44, while allowing the petition, my Lord, page 50, the observation is, my Lord, I have to pay cost of rupees 10 lakhs and but disputed portion is
What was the finding against you?
but finding against me is, my Lord, I have dispersed the entire amount. Thereby, my Lord, I have committed a misconduct is the, my Lord, observation of, my Lord, Honorable Learned Single Judge. That is, that may not be correct, my Lord. Your Lordship will find at page 4.
Just say issue notice.
Lord, I have been directed to pay report, my Lord, compliance within a period of 4 weeks, failing which, my Lord, page 58. Page 58, my Lord. For the purpose of compliance, my Lord, it was listed. Para 67. For otherwise, my Lord, I have to.
What happened on 3/3/25?
Lord, it was adjourned only on the ground that, my Lord, writ appeal is filed. I have to, Lord, I am bound by the direction. Your Lordship may stay only the portion of the.
What is your age?
Lord, my age, Lord, age is 55.
What is the retirement age?
60, Lord.
Just say this, learner counsel for the appellant states that the proceedings are going on before the learner single judge in view of paragraph 67 of the impugned order. He informs the court what is the date of hearing,
But no, my lord, no date is given.
then cut it. We will see it. Issue notice.
My lord,
You will say that appeal notice has been issued.
Lord, the difficulty is this, my lord. Your lordship may kindly come to, my lord, page 25. But the since, my lord, it was date was given, my lord, since the bench is not available, kindly come to, my lord, page 25. Since, my lord, the honorable judge is
Yeah, it's all right.
therefore, my lord, no date is given.
But there would be someone who is holding this roster.
Lord, I am bound to deposit before the concerned court.
We will see it.
But only the portion of the order, my lord, which directs.
We will see it.
My lord,
We have issued notice, if any, and it's only the compliance by the learner single
but
judge.
I have to deposit 10 lakhs, my lord.
We have issued notice, we'll look into it.
My lord, may I request this, my lord? Lord, your lordship may stay only the portion of the order which says I am directed to deposit 10 lakhs. My lord, kindly see my interim, my lord, prayer. Prayer is only to set aside portion of the order which says, my lord, at para 40, 43 and 44. I am not challenging the. I am not challenging the order of the Lord Learned Single Judge. I am only aggrieved by portion of. Kindly see the prayer, my lord, at page 24.
Now this 10 lakhs has to be paid to whom?
Lord, to Kidwai, my lord, Institute of Medical Oncology. But para 44 at page 50.
Oncology.
Yes, my lord. 44 SLO, that is appellant, my lord, shall deposit the said cost to the so and so within a period of 4 weeks. Only that portion of the order, my lord.
1 minute. There is a stay application.
A stay application, but I am seeking only that portion.
Yes, 1 minute.
Yes.
Just say since we have issued notice, comma, the deposited as directed by the learned single judge in paragraph 43, 44 is deferred by a period of 4 weeks. Okay. Is deferred till the next date of hearing. We'll say that, till the next date of hearing.
Then we want to submission along the law of timing. Not the previous matter may not have undertaken that I would serve a copy of the statement of objection. There are some annexures may not, I may be permitted to serve on the day after tomorrow.
He is the counsel, ma'am.
Not I've informed the counsel may not, she was here.
No, you ask the counsel to come at 2:30. In her presence, we should do it. Yes, yes. Kal the next matter. Huh? I don't know, they're surviving this court, man. There is a delay of 4 days.
2 days.
2 days.
2 days.
We will just delay, condone the delay. There is a delay, no, in your case.
But there is one issue regard.
Okay, we will issue notice on the delay also.
But you have mentioned 2 days, it is actually 8 days.
No, you see there is no delay.
There is no delay as such, my lord.
Actually, there is 8 days.
There is 8 days delay, it's just,
None of the counsel is present.
Please, my lords.
Ma'am, she says she will be able to serve you on day by 2 days after this.
Wednesday I'll serve it. But the
We have
date
fixed
may be
it
the
on
same.
Thursday. We have fixed it on Thursday.
Friday, my lords.
Friday.
27th
Give it
is
on
fixed.
Tuesday. Don't say during the course of the day. Say on or before Wednesday. Put a date. Yes, we'll come back after lunch.
My lords, I have one request. My lords. Post lunch, my lords, I have to go to Dharwad, so I'm not available in the post lunch session. This is the very next matter, in fact, serial number 52. Your lordships may recollect, your lordships had heard it for some time. There were some issues regarding maintainability and because the government order under question was with regard to opening of certain pre-primary schools. I had made a submission that the petitioner was admittedly in first standard, so therefore there was a question regarding locus and various other issues. So if your lordships could accommodate me another day, because at 2:30 I have a.
I represent the state in this matter, my lords. I represent the state in this matter, my lords. I
The-
appeal for appellant in this matter.
So the council, senior council wants a.
Please, no problem.
Let's say that.
With
You appear
convenience, we
for
will have.
respondent number 6.
Yes, Ms. Caveator.
Just say at the request of learner senior counsel for the respondent number 6 caveator for an adjournment on the ground of personal difficulty which is not opposed, re-notify.
Grateful.
Grateful.
13A.
We'll come back.
केमिकल, ना कपड़े में, ना हाथ में, बच्चों का लगेगा नहीं। बनाने के लिए कुछ नहीं, जोर नहीं लगता, आराम से ओवर हो।
अरे वाह, इतनी इजी बन गया है तो। क्या
घबरा के नहीं, आराम से।
हड़बड़ा के नहीं, कितना बड़ा हो जाता है? ओ भाई,
बड़ा तो आप जैसे मर्जी बनाओ। ये बैलून है, घरों में कई बर्थडे पार्टियों में लगा सकते हैं।
अरे वाह,
जब निकालना हो निकाल सकते हैं,
क्या
बच्चे
बात।
खेलेगा, टूटेगा नहीं।
अरे वाह,
अगर ये टूट भी जाए तो बनेगा,
क्या देखा ना। ओ भाई साहब,
फट भी जाएगा ना। ये
हाँ।
लिक्विड बंद कर दो,
अच्छा फाड़ के दिखा,
कहीं से बड़ा कर दो।
ये बड़ा हो जाता है।
अगर कभी गलती से बैलून है, बच्चा जानबूझ के फाड़ भी दे
और
तो कोई टेंशन नहीं, ये बंद होगा। जब तक जान है बना सकते हो।
अरे वाह, कोई बना सकता है इसको?
बच्चा बनाते हैं, मैं करना क्या।
अच्छा,
मेन ट्यूब है।
कोई ट्रिक नहीं है इसमें?
नहीं, ठीक का है, ठीक इसका इसी का है बैलून है।
अंकल जी गुब्बारे कैसे है?
मैं उसको हाथ मत लगाना, आइए इधर देख लीजिए।
दिखाना।
कैसे बनाने के लिए खाली ऐसा लगाना है।
अच्छा,
बच्चे हैं, इसको मुंह में डाल ले, ना केमिकल।
पानी के बच्चों को भी इस स्कूल में एडमिशन नहीं मिली। दिस स्कूल इज कॉल्ड इंस्टीट्यूट ले रोजी व्हिच इज बेस्ड इन स्विट्जरलैंड, जहाँ पे एक एवरेज बच्चा नहीं जा सकता है। योर फैमिली हैज टू बी अ बिजनेस टाइकून, तभी आपको यहाँ पे एडमिशन मिलेगा। यहाँ पे एक बार में सिर्फ 400 बच्चों को एडमिशन मिलता है एंड देयर आर स्टूडेंट्स फ्रॉम मोर देन 56 कंट्रीज ओवर हियर। यहाँ पे एक कंट्री से सिर्फ 10 बच्चों को लेते हैं टू मेंटेन डाइवर्सिटी। ये स्कूल में नॉर्मल पढ़ाई नहीं होती है, rather they are taught activities like snowboarding, horse riding and many other skill development subjects. Students are also taught subjects like taxation, diplomacy, reputation management, which will actually
Don't go to therapy. It's
So you bill, sir?
हाँ, thank you. खाना तो इस बच्चे ने बड़े दिल से खिलाया, एकदम श्रद्धा से। आजकल के जमाने में ऐसा करता कौन? मतलब इसको जब जब बुलाया तब तब आया। दिल से सर्विस करी है बंदे ने। 100 रुपए तो इसकी टिप बनती है, 100 क्या 200 बनती है। 200 क्या मेरे ख्याल से 300। तू बैठेगा जरा, तू बैठेगा, मैं भर रहा हूँ।
So you bill, sir?
हाँ, थैंक यू। खाना तो इस बच्चे ने बड़े दिल से खिलाया, एकदम श्रद्धा से। आजकल के जमाने में ऐसा करता मतलब इसको जब जब बुलाया तब तब आया। दिल से सर्विस करी है बंदे ने। 100 रुपए तो इसकी टिप बनती है, 100 क्या 200 बनती है। 200 क्या मेरे ख्याल से 300। तू बैठेगा जरा, तू बैठेगा, मैं भर रहा हूँ। Come on, homies, मेरे भी कुछ चाह नहीं यार, I told you। मैं बाहरों आवा थੱਕਿਆ ਟੁੱਟਿਆ ਤੇ ਮੈਨੂੰ ਆ ਕੇ ਕਵੇ ਜੱਗੀ ਜੀ ਤੁਸੀਂ ਥੱਕਦੇ ਨਹੀਂ ਹੈ ਮੈਂ ਨਹਾਉਣ ਜਾਵਾਂ ਤੌਲੀਆ ਤਾਂ ਜਾਣ ਕੇ ਭੁੱਲ ਜਾਊਂ ਤਾਂ ਮੈਨੂੰ ਕਵੇ ਜਾਨ ਤੌਲੀਆ ਤਾਂ ਤੁਸੀਂ ਭੁੱਲ ਗਏ ਜਾਨ ਤੌਲੀਆ
ਸਾਡੀ ਮੈਡਮ ਪੈਰਾਸਾਈਕੋਲੋਜਿਸਟ ਆ ਤੇ ਬਿੱਲੀ ਇੰਨੀ ਛੇਤੀ ਕਬੂਤਰ ਨਹੀਂ ਫੜਦੀ ਜਿੰਨੀ ਛੇਤੀ ਸਾਡੀ ਮੈਡਮ ਊਠ ਫੜਦੀ ਹੈ।
So beautiful, so elegant, just looking like a wow.
If you cook some pumpkin along If you cook some What if I tell you कि अब आप अपनी फैमिली के लिए फ्रेश आटा घर पर ही बना सकते हैं। सॉफ्टवेयर की ये मिलेट मिल एकदम कॉम्पैक्ट और किचन फ्रेंडली आप इसमें बीट से लेके Hey everyone.
कहते हैं वो कई सालों से ही इस हवेली में कैद किसी के खून के बूंद के ही क्या कर रही है कोई नहीं है इधर।
क्या हुआ? ये सब क्या है? अनन्या को लड़के वाले देखने आ रहे हैं ना, तो हम सोच रहे थे कि उसके लिए कुछ डिजाइनर कपड़े पहना है, कुछ समझ ही नहीं आ रहा ये वाली कैसी रहेगी। हाँ ये देखो, ये सब कुछ ज्यादा झकमक नहीं है। अब मुझे लगता है अनन्या को कुछ सिंपल पहनना चाहिए, और वैसे भी लड़के वाले तो देखने ही आ रहे हैं ना बस। नहीं दीदी, क्या है, लोग ना थोड़े रिच हैं, ऐसे तो हम भी किसी से कम नहीं है, पर थोड़ा बहुत तो दिखाना पड़ता है ना। और वैसे वो लोग ना बहुत ज्यादा ट्रेडिशनल है, तो हमें भी तो वैसे ही लगना चाहिए ना। हाँ, और बताइए ना अभी कौन सा अच्छा है, बताओ। ये देखो, बहुत क्लासी, अनन्या पे।
हाँ ठीक है, नोटिफिकेशन वाला रिट पिटिशन का देखो, ऑब्जेक्शन क्लियर, वो सिर्फ एक पेपर ही तो देना है टाइप 2 बार कर दिया ऑलरेडी, अभी तक नहीं आया, थर्ड मेमो डालने जा रही हूँ कल।
ಯಾರು ನಿಂತ್ರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್, ಯಾರಿದ್ರು ಅಲ್ಲಿ ಯಾರನ್ನೂ ನಿಲ್ಲಿಸಕ್ ಬಿಡ್ಬೇಡಿ.
Yes, Mr. Shetty. Are the respondents present? Those respondents to whom we have issue notice? And what about the, pardon? DNA. And the notice, you see, we'll do one thing. Now you have filed your reply. Pardon? Amended is only, you're right, you must get it. Ma'am, we'll ensure it, you get that. Amended is adding these 3 respondents. You have? Just give it to them. Pardon? Status report will be, in fact, that's one of the reasons. What is being said is that it must be kept in the seal cover. There is another view, it should not be, it should be made available. We have not taken a call on that. We wanted to hear it. Everyone, including Mr. Shetty and Mr. Hulla, we want to appoint an amicus who would also assess the court on this aspect as well. So that's the one of the reasons. Now we have issued notice, we'll appoint an amicus today. We will have it. We will intend to, because you pending a decision whether the report must be given to the other side or not, you can also file your reply in whatever manner you want. If ultimately we take a call, either way, we take a call to that you should be entitled to, possibly you can file a response to that. That can be thought of, not an issue. So we will just show us that.
Page number 27 and page number 42. This may have to be deleted from the petition. Kindly happen.
20.
Page number 20, 42, 27 and 42.
That's B5.
Yes.
It's in Kannada.
It's in Kannada. No, it's not.
Yes.
Language used against the honorable court, it should not be retired.
40.
Page number 27 and 42, my lord, it's a repetition. Page number 22, 27 and 42. I think, my lord, these 2 pages, this has to be deleted from the paper. Otherwise, my lord, it uses very bad language on this text.
We will see that. The only thing is, reference was made to certain communications received by us. The fact only is, just only a reference is as a communication, nothing more. If you see the petition may not having these averments.
Certainly not, but it's a.
We will see that.
This doesn't carry a great
1 minute. Which line you are reading?
I am reading, but I don't want to read it, my lord, loudly.
No, you would not. We tell the line.
Kindly, my lord, see the titling on the
First
top.
line.
First line itself. And my lord, the first line after the email.
Just 1 minute, Mr. Okay, we will look into that. Surely.
2 pages has to be first.
Very well, we'll look into that. We'll look into that. We say nothing on this. So just say this, pursuant to the last order. Now, who would be briefing you for the KSCA?
It can't be. None extra copy.
Say that the senior counsel through so-and-so advocate are present for the KSCA. And what about the DNA?
DNA is respondent number 4 by Surat Sab.
So-and-so and the senior counsel with through so-and-so are present. Full stop. They seek and allowed. How much time you want? We will have it just on or before Friday. You must file it on or before Friday.
The only reason is that there are multiple inquiries going on in that state taxes. So CH-2s are also.
Well, also kindly have, I have asked.
Of course, we are going to answer, I'm not saying no, but.
A week's time.
Supplementing my learned question, Nanda, my lord, I have one submission. You will also kindly have, my lord, the first order. The first order, at paragraph number 2, my lord, should have 3 questions framed.
That's right.
Which requires answer. My lord, insofar as the first question, my lord, the reasons which led to tragedy. My lord, there are about as many as 5 investigations today that are going on. Number 1, my lord, is the magistrate inquiry, which is, my lord,
Let them all put it in writing, my lord. Let it.
Whatever you deem it appropriate to put it, put it.
Whatever my lord is saying, we cannot, my lord, deviate from the statements we have already made. But we place everything. Insofar as, my lord, the third aspect, my lord, what remedial measures need to be taken, my lord, that we may have to, my lord, say, my lord, in a general, my lord, sense, that as, my lord, the responsible cricket organization, as, my lord, the citizens of the.
Whatever, obviously, whatever you want to put it. Okay.
No ball batting much other.
Yeah, just say that given the fact that this court had taken a suo motu cognizance of the incident which happened on 4/6/2025, we deem it appropriate to appoint an amicus curiae to assist this court in regard to this petition. Accordingly, we appoint Srimati S. Susila, senior advocate, as an amicus curiae who shall assist this court. The registry is directed to furnish the copy of the writ petition along with the documents annexed therewith, Mr. Shetty, the amicus will have the status report of yours.
Please, madam. Please, I understand. I know the reason. I've gone through it. Yeah. To assist your lordship, I bow down to your lordship. There's no question.
Along with the status report submitted by the state on 2 occasions, and
unless it is given, they won't be able to the position to assist your lordship as to what should be done.
That's right. Along with the applications on which applications which have been served on the state to which a reply was called for, and also the newspaper cuttings which form part of the record.
Your lordship may say that whatever. If I may submit a. Yes. The petition copy, annexures, status report, and all the IS filed in this, I'll submit.
That's right.
So that
shall be Ms. Susila. We are just appointing you as amicus. We will ask them to give you the complete record within a period of 2 days from today, and have your just look into it. We will intend to have it after 1 week, immediately after 1 week. By the time you file your reply, just go through it. If you want to file anything by statement of sort, note of submissions, everything, you can file it. But there is one issue which need to be looked into is also this. We'll be requiring your assistance on that. Is they have filed, the state has filed 2 reports. One is on the first day, that is no issue. The second, they have filed it on the queries we had put it for them to file a report. They have filed it, but they have, on the request of the learned advocate general, he requested that this must remain in the seal cover. So we continue to remain it in the seal cover, but there are 1 or 2 applications which have filed. It should not be in the seal cover. It should be brought in the public domain, or it should be brought outside the cover, something like that. So we wanted to hear everyone, in fact, on that data. Possibly Mr. Shetty will continue to have that view. It should continue to be remain. There may be another view also. It should be brought. So we would like to have your assistance also on that also. But we are giving you copy of that in a seal covered for your consumption. That we will do.
And
pardon? That can be served. Whosoever are the applicants in those IAs, they can give a, that possibly is not directed against you. There are broadly 2 kinds of applications. One is the report must be brought out. 2 is for enhancement of the compensation. That's primarily, it appears to be whosoever has paid the
Absolutely.
compensation.
These are the
No
two
one has
main.
filed objections, my lord, to those applications till
That's
now.
right. But who had filed initially paid the compensation? The state?
State, my lord, first initially.
Any of the other respondents?
State has paid till now.
State has to answer
State
it.
has paid. We had made an announcement, we've been asking for details of the persons in whose name we received the details today. We will make good whatever was announced by the explanation that we made.
No, we just want to know, we are also, against whom those applications are directed.
I do not have a copy of that.
That's right. You, whosoever are the applicants, I think you must serve the other three respondents who have now come in.
Yes.
Okay. Now we take it, we will file it within 1 week. So by Monday, we will have it on Tuesday or Wednesday. The matter.
On behalf of KSCA, we have announced that the next batch account. We are ready to discuss, but we have to get the details, the necessary from the DKM.
We requested the learned council.
If the gas will give
Some
it.
of those details have been given to us.
Possibly that application may have, would say so.
We shared the data, but they need to.
Full stop.
It will just take 2 minutes. If they ask us, we'll give it.
No, we'll furnish copies, sir. We'll furnish copies. We'll furnish copies, sir. We'll furnish.
Pertaining to sealed cover, my lord.
List of the victims.
No. Pertaining to sealed cover, my humble submission is, it may be uploaded because already in public domain, it is the content of the sealed cover has been disclosed.
We say nothing, just reserve it for the next date. We will hear you, everyone. We will hear the learned amicus also. We'll have it. Now we will have it on Tuesday. Tuesday.
Oh, one submission, Lordship. One submission I want to make. Now your Lordship kindly, they filed the Kabanpur police have registered FIR in crime number 123. Now the present respondents were all now implemented as a party now. They all challenge that. For any reason, the learned single judge question, the entire proceeding goes because foundation is on the FIR, your Lordship. So because the single judge hearing and all evidence will go, that has to be also examined, you know. That's what I said in my application. Entire thing goes.
Responsibilities. At the same time, we also have a right to challenge if something is happening wrongly.
No, they also have a responsibility on the
Tuesday,
people who
next
died,
Tuesday.
because we are concerned about the
Thank
death
you.
which has taken place.
And our scope, we have.
Yes, Lord, that's what we think.
Not go beyond that.
I know that, Lord.
I have one submission. IN number 11.
No, my humble request is administrative side. Those writ petitions also can be clubbed here because in earlier case it has happened in earlier PL several. In all administrative, these writ petitions also can be clubbed along with this, and because the grounds urged is.
We have, once the court has taken suo moto, we are just re-notify it on those days, those petitions which are listed. We will see it. Intervention applications, we have not disposed of. We will hear them, learned
Yes, sir.
amicus. If any assistance, we will
Please.
see it. We say nothing at this stage. Except the fact that those applications which have been filed for the opening,
We'll give
possibly we require that kind of an assistance.
Yes, sir.
And the enhancement which is sought.
Please.
Thank you.
Lord, one observation. Lord, one observation may help in the interregnum, Lord. While they are offering that they'll pay, Lord, the Lordships may observe that those payments to the victims, Lord, can be made in the interregnum by the KCA and by us.
Tell us, Mr. Naganan, was it a voluntary act on their part
No, Lord,
to give compensation? You're on compensation, huh?
yes, my Lord, they have, both of them have offered ex gratia. They have asked us, my Lord, to give the details. Some of us have given. So I'm only requesting, my Lord, one observation will help them to finish this in the interregnum.
We don't want to say anything. Whosoever have expressed themselves, you have heard Mr. Naganan. You have heard Mr. Naganan.
Let me take it as an
excuse.
And the
tomorrow
learned
that will
advocate
make a-
have heard it. Whatever Mr. Naganan has said, possibly you will take in accordingly.
No, your Lordship, the larger issue is.
Names of all those.
Now, Mr. Naganan, you have heard Mr. Shashi. It's intersect between both of you.
We take that.
Okay, we don't want to say anything,
Yes, sir.
not even in one observation saying that you should pay. That does not mean, should not be mean that we have taken a call. Intersect, if anyone said voluntary, we are giving it, it's between both of you.
Because the larger issue is that they have to answer to the points raised by this court on 5th June, Your Lordship.
That we
That is
will see.
important. We
Mr.
can only
Mohan,
consider on that so
if it
that
permits, my lords.
in future it should not happen, at least.
If my learned friend permits, my lord, larger issues can be decided. Thank you.
Even the state is not answered the three questions.
Three questions, till today they are not answered.
That's our reference.
If they answer the three questions, I think the entire.
Let's see. Let's see. Thank you.
I have one
disclose my
submission. I have one submission. IA number 11 of 25 filed as a party in person. My contention is that the state has initially awarded a compensation of 10 lakh rupees to the victims in family. Later it has been increased to 25 lakhs. There are more tragic incidents occurred prior to these events, my lords. Just 15 days prior to this tragic event, there are a number of events wherein 15 farmers died due to thunderstorms and lightning in the state. Last week also in Bangalore, my lords, last 3 days back. No, my concern is, my lords, state is awarding the compensation at their whims and fancies, my lords. My contention is, let the court direct them to frame on guidelines regarding the quantum of compensation amount to be paid to the different victims of different causes of death, my lord. Because for last 7 months back, my lord, due to consumption of contamination of water in my Tumkur district, 6 people died. There was a petition before this honorable court. There was a contamination of water. It has been disposed of by this honorable court. So none of them have been compensated with even the guaranteed amount of 5 lakhs rupees or 2 lakhs rupees or whatever. They are begging till today. In this case, my lord, last week itself, my Tumkur district deputy commissioner handed over a check of 25 lakhs rupees to the king's office. This is my contention is this, that the farmers or whoever, one fixed amount, it is to be decided.
You will see, we say nothing on that. We say nothing on that. Thank you. Tuesday.
Number 82 in this matter.
Just re-notify. Re-notify. Come, ma'am, next matter.
So number 53, Shanandra.
Here for the appellant.
Ma'am, what happened in 51, ma'am?
This is an order.
Yes. Yes.
53.
Now, different number 3 is in appeal. The order under challenge, my lord, is an order passed for attachment before judgment by the commercial court. Now, my lord, the application was filed under order 38 rule 5. The commercial court, my lord, has passed an order saying that if I fail to, my lord, furnish security, then, my lord, the property, my property that is shown in the schedule will be attached. So therefore, my lord, I have filed this appeal. Now, the office objection, my lord, is that insofar as an order passed under order rule 5 of order 38, appeal is not provided. But insofar as an order passed under rule 6 of order 38, my lord, the appeal is provided. So my submission is, my lord, since there is already an order to attach the property, it amounts to an order under rule 6. So therefore, my lord, it is appealable under order 43.
43 contemplates 5 or 6?
43 contemplates of 5 minutes.
6.
43 contemplates of 6. Sorry.
It doesn't contemplate 5.
It does not contemplate.
So why
5.
should we read into it?
Lord, reason is, my lord, we kindly see page 33, my lord, the impugned order.
the order is the applications are allowed.
Which page you said?
In page 33.
33. Yes.
There are two applications were filed.
Are hereby allowed.
Yes, I'm not, second operative portion of the order. The first operative portion, there were two applications, IA2 to dispense with pre-litigation mediation, and IA3 which is for attachment before
So 38.5 is actually to furnish the security.
No, 38.5 is to furnish security, failing which to attach the properties.
38.6
yes,
will flow.
6. So,
but we are at stage 1, 5.
Virtually, there should have been two orders. One is directing a notice on the application, directing me to show cause.
Tell us one thing, 6 will only come when there is an order in 5.
Yes, my lord.
So order in 5 has come.
My lord, order in 5 and 6 are together.
We don't know.
No, that's what the order says.
You don't know.
No, your lordship will kindly come to second
It's simple.
paragraph,
It's just simple. Let's not read into order 43 something which is not contemplated.
Yes.
And mind it, that order has been read into the Commercial Courts Act.
Yes.
Order 43.
Yes.
And they said only those which are listed under order 43 would be subject matter of appeal under 13(1)(a).
Yes.
If this interpretation is given, everything would be read into order 43, which means everything is read into 13(1)(a). How would you answer that?
Look, may I just take your lordships through the second and third operative portion of the order, second and third para, and the next order that is passed by the Commercial Court. The second operative portion says, defendants are hereby directed to furnish secrecy to the court to the extent of so and so rupees, which is a suit claim. Now, this falls under order 38, rule 5. Now, next paragraph, if the defendants fail to furnish as ordered here above, the scheduled property shown in IA number 3 shall be attached. This comes under order 38, rule 6.1.
Just show CPC.
Order 38, rule 6.1. Because the next date, straight away attachment warrant is issued.
If you fail to.
Yes, so I did not furnish security. So next date, there was no order of attachment. Straight away, attachment warrant is issued. So therefore, the third paragraph of the operative portion is, order 38, rule 6. Is an order under order 38, rule 6.
You mean to say that there should be a finding that you have not complied with the order?
Yes,
Why?
Order 38, rule 6.
Not complied.
Order 38, rule 6 says, ideally, there should have been two orders. First order to say only at it should have stopped at para 2 to say that furnish security or else we will attach your property. Next, order 38, rule 6 would follow, saying that you have not furnished security nor have you shown reason why you should not furnish security. So therefore, we are attaching your property under order 38, rule 6.1. That would have been the ideal situation, but here, the court has said if you fail, then the property shall stand attached. So therefore, 5 and 6 are combined. So that is not one judgment,
Which you are challenging?
I am challenging this order, Milords.
Second one.
No, I am challenging the entire order.
How come?
Both 5 and 6, because that is the order that has been passed.
For the second part, forum is different. First part, forum is different.
No, second part merges with
See,
the
no. That we will not allow. That's clever argument. Under the pretext of challenging the later part,
yes.
You are challenging the first part. You tell us you will not challenge the first part, we will be with you. We will be with you.
Yes.
If you say so, you are not challenging the first part.
The second portion, second operative portion.
We will confine our appeal with this.
Yes.
But you will not challenge the first part.
No, ultimately, the second part, the first part has merged with the second part.
No, let's forget the merger here, because 43 makes a distinction between 38.5 and 38.6.
38.6.
Let's be clear on that.
Yes.
So 38.5, you have the appeal is not maintainable.
Yes.
38.6 maintainable.
Yes.
That's why we are saying you will say so. You are not challenging the first part, that is the attachment part, not the attachment part. Furnishing the security, you will not challenge. We will see the later aspect.
But ultimately, the entire order will not.
No. I think this is how we must interpret the provision also. We will say so. You are right.
Yes.
Because this order incorporates an order under 38.6 as well. Because furnishing security. That's 38.6.
Yes. So we will 5 Milord. To furnish security
No.
is 38.5.
Failure to furnish security
Yes,
and
38.6.
attachment
Attachment.
follows.
Yes.
So we will look into that.
Yes.
But first part, you will give a statement. You are not pressing your appeal qua order under 38.5.
No, ultimately it is one order.
We don't know ultimately. We know what is the provision. We want to give a purposeful interpretation of that.
Lord, may I rely upon some judgments, Lord, because
Let's be very clear then.
yes,
We take by this submission, your intent is actually to challenge 38.5, and we will dismiss this appeal.
Lord, I intend to challenge 38.5 and 6.
You will not say so. We are putting it to
Because,
you.
Lord, ultimately when appeal remedy is available, Lord, I will
Okay.
have to choose the appeal remedy itself.
Let's rephrase it. This appeal is triggered because of an order under 38.5. Are we right in saying so?
Lord,
Are we right in saying so?
Lord, 38.6, I would respectfully submit 38.6.
Okay, 38.6?
Yes.
Then don't press 38.5. It's your case. Don't press 38.5.
But I may be permitted to assign the reasonings, my Lord,
Nothing related to 38.5.
because the reasonings are the same for 5 and 6.
It can't be. We will say so. Why? 38.5 is for furnishing security.
Yes.
38.6 is attachment.
Yes.
For furnishing security, we will not look into it. We will see whether attachment was justified or not. That's all.
Lordship may have it. Tomorrow, my Lord, I'll take instructions, my Lord. I'll take
See, we have seen it under the pretext of 38.6. Effect is 38.5 being challenged, which we will not permit.
I'll take instructions, Lord, may have it tomorrow, my Lord.
You'll have it.
So there are some judgments, my Lord, which says that in the order of this nature, appeal is maintainable because ultimately when the appeal is provided, appeal has to be preferred.
But then why the legislature
Yes.
has not said under 43 anything which is ancillary or connected there which should also be subject matter?
That is not good, sir.
That's not there. We are reading into it. Today 38.5 would come. Tomorrow something else would come. We don't want such a situation. Then it would be endless. Everything will be read into, which we don't want. The legislature, and we can't do it.
The only reason why I filed appeal is one of judgments of Calcutta High Court says that not
We have read that, we have seen that
yes,
judgment.
eventually, if an application is allowed, then my Lord, it would cover under Order 38 Rule 61.
What is allowed? 38.5.
The application, yes.
But need to be segregated. You must say so. What was the intent? Intent is 38.5, not 38.6. Yes. So 38.6 is primarily with regard to attachment.
Yes, sir.
With regard to attachment of the security. So furnished, order was right.
Yes.
Whether attachment could have been made. You can argue, look here, very well, I have no issue with furnishing a security, I will furnish. But they could not have attached it. You can argue that. But you will not argue the first one. Whether the order to furnish, direction to furnish a security is justified or not.
Yes.
Okay. At the request of counsel for the appellant.
The application that they filed, though styled under or Rule 5, it seeks for an attachment virtually under Rule 6.
See, they could not have said so. Unless 38.5 is satisfied, they will not move to 38.6.
But that is the application. They style it as under Order 38 Rule 5. But they say the scheduled property should be attached.
38.6 will follow 38.5?
Yes, ma'am.
Unless there is a 38.5 order, how can they be 38.6?
There cannot be.
And so, and that's the reason 43 confines to 38.6. At the request of counsel for the appellant, re-notify. Just give a normal date.
Lord, any shorter date?
We'll give you that. You take a call. You have not said so. We are ready to hear you today.
I'll take, even if it is had tomorrow, my Lord, I will take instructions, my Lord, from you. I'll just intimate the party.
Just give it next week. Give it next week.
37.
3. Apply.
54. Second number 54.
Lord, there's one more objection regarding court fees, my Lord. The court fees I have paid as per the schedule. The office has raised an objection that it should be ad valorem, my Lord, which is when a final decree is challenged. So this is, my Lord, otherwise would have been an MFA. As per Schedule 2, my Lord, I have paid the court fees. The office says ad valorem court fees has to be paid, my Lord.
We will look into it. Just remind us on the next date.
Yes.
54.
Yes.
The appeal under section 37, my lord. I am the respondent in the arbitration.
Yes, show us the file, man.
Represent the respondent.
And I'm I'm unsuccessful before the arbitral tribunal. In my 34 also, my lord, I'm unsuccessful. I am here before your lordship under 37. The impugned award, my lord, is 8 September 2023, available from page number 67. I'll begin with my lord, the impugned award, then take your lordship to 34. The basic facts of the respondent is the landlord. I am the tenant. I own mobile towers. So I had leased the roof terrace portion of the portion owned by the
We'll have it some other day. It may not be possible.
There's some BESCOM charges that are to be paid. And we are now saddled with 30 lakhs and odd. I have made an application.
And only difficulty, and of course, they have not initiated execution. In the event they initiate.
You deposit here. Deposit the decretal amount or the awarded amount. How much is the amount?
30 lakhs.
Deposit.
At 30 lakhs, 32,844 and 7 lakhs as rent.
Deposit it. We'll
And
stay
rent
the-
arrears.
We'll stay the enforcement. Or we'll take his submission. He would not. Once let him deposit here.
The problem is this, Brad. BESCOM authorities have initiated action for recovery of this amount.
Okay.
And it's an electricity arrears due. There is a agreement which is called as an electricity agreement, which they have taken. They have given an undertaking that they will pay the electricity charges. Now the BESCOM authorities have said we will disconnect the power supply of the remaining portions of the property.
So what do you
Now
want?
this amount is not paid.
To them? No, it will not come to you.
It will not come to me. It will
It will
go to
come
the
to BESCOM.
BESCOM.
Okay.
I filed an application.
Now
to
tell
that.
us one thing. Now what has been determined is the the liability has been determined. Who should pay?
Liability has been determined of the BESCOM.
Now let's
electricity.
assume for a moment the money comes to you, goes to ultimately to
It does not
BESCOM.
come to me.
Or he will pay directly to BESCOM.
Just let him pay it.
But how would you, if ultimately he has to succeed, how will you secure that?
Not my property itself is there.
Hmm?
My property is there. This is a scheduled property where I am the owner of the property. I am the owner of the property. And he was a tenant under me.
Okay.
He's a tenant. He doesn't pay electricity charges. He does not pay anything.
Can I only take you to my lord's page number 91, paragraph 30. Lord, it is not the electricity charges per se. That submission may not be correct. There is, my lords, an LT3 license, LT3 connection and an LT5 connection. Lords, what was existing on the property was an LT5 connection. What was supposed to be taken was an LT3 connection.
All that is
Because of
determined, my lord. Those facts have been gone into, trial has gone
I
into.
just complete not LT5 and LT3. Because of that, not there is a back billing charge which is there. The BESCOM says, look, you have taken the wrong connection. You have to pay the back billing charges. That is what is impugned. Not if I will just take your lordship's page number 91, paragraph 13. This is not the finding of the learned arbitrator. All of these back billing invoices that have been raised, my lords, have been quashed by this honorable court. I will just read paragraph 13. The net outcome of the discussion made above is that there is no final order by the BESCOM which can be executed either against the claimant or the respondent with regard to the back billing charges, and therefore the respondent cannot be directed to pay the amount which is claimed in the claim petition to the. To make it further clear that the earlier demands made by BESCOM authorities were held to be illegal and contrary to law applicable. When the demands made repeatedly by the BESCOM are held to be illegal and contrary to law, a direction to pay that amount, whatever was claimed in the demand notices to the respondent, would not be appropriate. This, my lord, is a categorical finding of the learned arbitrator. However, my lord, why I am saddled with a payment is they have litigated these matters. All of these notices were litigated. There was a pre-deposit that was required. That pre-deposit, my lords, for the illegal act of the BESCOM, learned arbitrator has said you have to compensate the respondent. He categorically finds that all these back billing charges are illegal. Whenever these back billing charges are challenged before this honorable court or before the appellate tribunal, because of a statutory deposit, he was compelled to pay. Now, my lords, because of his compulsion to pay that amount, because of the BESCOM's mistake, I have been saddled with the amount.
I will deposit it before this court, not, but I need not have to deposit to the BESCOM because.
See,
it has
what
been-
he is saying is that BESCOM is threatening the
But
disconnection.
they I have produced the notice copy also, Milord. I've placed it, a copy of which is sent to him also, Milord.
I don't have a copy of the.
No, I have given it,
direct-
sir, it's
I have got
served.
direction only. Copy is not part of it. Notice is not part of it.
The mobile tower now would be dismantled.
Yes.
No, Milord, he has not delivered possession. He still retains, all those material are still there in the premises. Rent is not paid. It is continuous. But it's threaten on a landlord, Milord. What can it be done?
But this is only for the usage, for the permission granted to install the mobile tower.
But a lease was only for the purposes of installation of mobile tower.
Right.
He used it. We terminated his tenancy. Thereafter, he continued. Even today, he has not delivered possession.
He didn't have the separate BESCOM connection.
Yes, Milord, he has. He has.
Why have issued notice? It has to be.
But that was because the BESCOM wanted to disconnect in regard to the remaining tenanted premises. That,
Why?
but the rules are like that, Milord. If one tenant does not pay, the whole of the complex will be discontinued. I'll suffer, Milord, I'll suffer. That's the regulations, Milord.
So you have paid that amount now?
No, he has not paid, Milord.
It is your own connection.
What is
If there is a finding, is there?
No,
out
what
of
has
these
happened
land?
is the back billing charges have been quashed.
Correct.
No, there is no quashing.
Let
That's
it
a wrong
be back
statement.
billing or whatever it is. If they are demanding money, bill from him.
No, the license that is taken is wrong. It is not the electricity.
Tell us one
charges.
thing, we are more concerned now. If you were to succeed in 37, you would get back that 30 lakhs?
No, he has deposited it. So what the learned
I
arbitrator
have not paid, Milord. I am under a litigation. The BESCOM has issued a notice saying that I must pay it before 5th of July. If I don't pay it, the whole complex will go to
No,
darkness.
you're right. Today, 30 lakhs have been determined against him.
Yes.
That's right. But we are thinking now, suppose he was to succeed in 37, what will happen to 30 lakhs? Then the liability would not be on you. Are we right in saying so?
Yes, Manoj, if I may just clarify one aspect, what has happened actually is it is not the billing charge, the back billing charges which are there. The back billing charges have been quashed, and whenever he has challenged these back billing charges before this honorable court or before the appellate authority, he has made deposit of certain amounts in various tranches.
So this 30 lakhs is
30
again,
lakhs is that amount which is in deposit before various courts. It is not the amount that is claimed by the BESCOM. This is there in paragraph 14. If I may read, continue to read. On
But
page
where
number
is that
91.
amount? Let him say so.
so we just want to know that very well, 30 lakhs you will pay to BESCOM. Can we say so?
Or then deposit before the court, Manoj.
No, but the difficulty is you have to see from his perspective. He said that they are now sitting on their head saying that we'll connect the rest of the electricity.
That bill is for your connection, isn't it?
No, it is for the back billing charges because they had taken a wrong license. It is not for my bill. It is not that I have not paid my electricity bills. There is a back billing charges. And back billing charges, the appellate authority has held that you can do it only for 2 years. BESCOM is doing it from 2000.
Is it your case you are not entitled to pay this 30 lakhs to him?
Yes.
That's your case,
That is
no?
my case, yes.
Now, but in any case, to obviate a situation where the disconnection may happen, suppose you pay directly to BESCOM, okay? Now the question would be, that's what we are putting it to, if you were to succeed in this 37, whether this 30 lakhs come back to you.
It has to come back to me because then there can be no liability.
It's only we want to see ultimately 37, we have to balance all the equities. So if ultimately, Mr. Simka, you have to answer it. Suppose for a moment.
My property is there, Milord. It will stand as a security.
Can I just take instructions on whether deposit?
Exhibit P6 is the loan agreement, the agreement for power.
So otherwise we'll bind him through a personal this thing undertaking.
Yes.
If we don't succeed, he will repay you 30 lakhs with interest starting from the date of deposit with the BESCOM.
Can I just take instructions on the BESCOM or the court on that aspect and the instructions I'm willing to deposit
for this court is the instruction that I have.
See, that may not really suffice the purpose.
I'll also explain why I am hesitating from saying I will deposit before the DESCOM.
Why?
Because I have not seen the notices. If I were to see the notices and if I were to absolutely discern that it is because of these back charges that DESCOM is putting up this claim of 30 lakhs.
You have the notice, you have the notice.
I don't have it. I don't have it.
Why don't you give him a notice?
And I'll give him the copy.
The one, Mr. Shivkumar, give the notice to him.
I'll have a look and I'll come back.
Just say that, learner counsel for the.
There's some urgency, my lord. 5th
Respondent
July, they
number
may
one.
disconnect everything.
You are right, we are conscious of that. 1 and 2 has handed over the copy of the notice received by the respondent 1 and 2 to the counsel for the appellant, who seeks some time to look into the same and take instructions. At his request, do you notify on? Just have it after 2 weeks.
But by which time, my lord, I may have to.
Okay, how much time? What is the time?
5th July.
If you just have it on 3rd or 4th, 3rd July.
37. $55.
Appear for the.
Yes.
Yes, Your Worship. The appellant insurance company being aggrieved by the order passed by the learned single judge, allowing the writ petition and also awarding the notional promotion from the post of administrative officer to the assistant manager, Your Lordship.
Yes, Mr. Bhatt, what do you say?
Lord, in this case, Lord, the learned single judge has, Lord, taken note of the fact that, Lord, in the earlier proceedings, Lord, this respondent was granted the benefit of reinstatement and continuity of service and all other consequential benefits.
But how can there be direction, a sort of a mandamus to promote him? Should have left it to the DPC.
No, my lord, now here the learned single judge has taken care of that situation eventuality also.
How?
Yes, my lord. But now please turn to Lord, page 33, para 9. Lord, after Lord, referring to that promotion policy para 9, as could be seen from the above, the consequential benefit of promotion to the petitioner was denied by the respondents on the ground that under the seniority cum merit policy, an assessment was to be made on the basis of the performance appraisal system, and since the petitioner was out of employment from 1911-1998 till 27-12-2008, there was no possibility of an assessment, and therefore his claim for promotion was not tenable. It is also the ground raised by the respondents that from the year 2007, all officers had to qualify through a written examination, and since the petitioner had refused to take part in the written examination both in the years 2009 and 10, he would not be entitled for promotion after the new policy came into effect. In the counter that is filed, the respondents have stated as follows. The petitioner is seeking promotion during the period from 20th of November 1998 to 19/12/2008 on the basis of prevailing promotion policy effective from 1990, but remained in force till 2006. The petitioner was under suspension from 20th of November 1998 to 12/9/2002, and from 13/9/2002 he was dismissed from service till he was reinstated on 19/12/2008. Thus, during the period 20th of November 1998 to 18/12/2008, the petitioner did not render any service to the organization. The petitioner belonged to 1995 batch of the officers, and this batch was not considered for promotion till 2003. When the petitioner's batch came into reckoning, he was already dismissed from service on account of conviction passed by special court. It is settled law by the Supreme Court in Deputy Director of so-and-so, Nagur Meena, that it may not be advisable to retain a convicted person in service. There was no scope for assessing his performance during the above period, without which evaluation of the candidate for promotion is incomplete. The promotion policy of 1990, Annexure A. As could be seen from the said paragraph,
The respondents admit that the petitioner's batch of 1995 was considered for promotion in the year 2003. And when this batch came into reckoning, the petitioner, having been dismissed from service, could not obviously be promoted. As already noticed above, this court directed not only reinstatement, which was confirmed by the apex court, but subsequently also specifically granted 35% back wages, continuity of service, and consequential benefits. The consequence of this order is that the petitioner is deemed to have been in service though he was terminated on 13/9/2002. The petitioner consequence of him being in service from 2002 is that the petitioner would have to be naturally considered for promotions. The promotion policy of the respondents indicate the criteria for promotion. Lord, I'll just skip off that whole paragraph. Then paragraph 16. As could be seen from the above, the selection for promotion is required to be based on seniority, insurance qualifications, and merit cum growth potential as brought out in the performance appraisals. It is to be stated here that the note regarding selection in clause 7.1 would not be applicable to the petitioner since he was not entitled for promotion to the cadre of manager. As could also be seen from the above policy formulated for the purpose of promotion from the post of administrative officer to the post of assistant manager, 42 marks are awarded to the seniority, 8 marks are awarded to the insurance qualifications, and the remaining 50 marks are relatable to the traits indicated in the confidential records, performance, and growth potential. As could also be seen from clause 7.1, no minimum marks are prescribed for grant of promotion. It is therefore clear that the promotion is not by way of selection, but by way of an assessment which is based on seniority, insurance qualifications, and merit growth potential. Admittedly, even according to the respondents, the petitioner's batch of 1995 was eligible for consideration for promotion in the year 2003, and it is not in dispute that the petitioner did possess the necessary seniority and insurance qualifications in 2003, and as a consequence, he would be entitled to 50 marks automatically. As far as the remaining 50 marks are concerned, since the petitioner was not in service, the question of relying upon the confidential record and the performance and growth potential would not arise. In my view, since the selection is primarily based on seniority, apart from the 3 other factors, having regard to the fact that the petitioner was not in service and that the petitioner possessed adequate seniority for promotion, the petitioner would also be entitled for promotion from the post of administrative officer to the post of assistant manager. So, this is the finding. So, therefore, my most respectful submission is the fact that I was not in service, that will not come in the way of my promotion, because my order of dismissal has been set at naught, and I was held to be entitled for all the consequential benefits and continuity of service. So it is only on account of the fact that I was kept away from employment, my chance for promotion has been affected.
What do you say, ma'am?
Your Lordship, my learned friend has skipped to the most important paragraph, that is para number 15, Your Lordship. When it has been stated, the promotion policy of the respondents indicate the criteria for promotion and weightage, and the same reads as follows, Your Lordship. That's 7.1, Your Lordship. In that, there's a table given by the learned single judge also, which is in accordance with our promotion policy. So what the learned single judge has taken into consideration is only the seniority and the insurance. That is for the seniority 42 marks, and for insurance 8 marks. That's how he has come to the conclusion that 50 marks. There is no minimum marks prescribed by the policy by the insurance company.
But tell us for from 98
yes,
till 2008.
He was not in service, Your Lordship.
He was not in service for 10 years.
Yes, Your Lordship. Therefore, Your Lordship, I would like to bring to the consideration of this honorable court that this promotion policy also includes, that is C, Your Lordship, CR form, traits in CR, performance and growth potential. These two were not available to the petitioner because he was out of service for a period of 10 years.
Yes.
Therefore, yes, Your Lordship. And even as per our policy, promotion policy also, that I may require Your Lordship's kind attention to page number.
He is for which post? Promotion is for which post?
Administrative officer to assistant manager. And
so
he
it
also
would be, okay.
Yes, and he also requested trade for from the post of assistant manager to deputy manager also. The learned single judge says that he is not entitled for the deputy general manager post on the same, based on the same promotional policy. But yet he goes to say that he is eligible for.
Why does he say he is not entitled for deputy manager?
The reasons are not forthcoming, Your Lordship.
Pardon?
Yes. Yes, Your Lordship.
Let's see that.
Yes, I'll read the relevant portion, Your Lordship.
So what you are saying is for one assistant manager, he allowed it,
Yes.
not for deputy manager.
Yes, Your Lordship.
Very well. They have not come in appeal.
They have not come in appeal.
Now, what is the ground on which he is not allowed?
Yes, yes, Your Lordship. I read it, sir.
Paragraph 23, paragraph 23.
Yes. Thank you. As
Very
far
well.
as-
That's on the ground that he did not take it deliberately, the written exam.
But Your Lordship, while considering that promotion, Your Lordship, there is another part of it. Not only the seniority and the insurance qualifications, but what is required for promotion is that their performance and growth potential. For that also remaining other marks.
But
50
ma'am,
marks
when the ACRs have not been returned, how would they be screened for those parameters?
That's the reason, Your Lordship, that is not, since that was not available, the learned single judge was not right in considering 50 marks.
See, you can't, then otherwise, the gentleman who has not, for certain reasons, for 10 years, he had not put in any service.
Yes, Your Lordship.
That has been set to naught. You can't deny him
And there
promotion.
are some citations, Your Lordship.
Sure.
I thought I'll just, may I request Your Lordship, because I have got only one copy, I couldn't get it. So there is a delay of 103 days. May I request for condoning the delay?
That
So
we
I'll
will
get ready
condone,
for
ma'am, for
final
what is on
disposal in the
merits.
next week.
But there are judgments otherwise also, similarly on this point. And mind it, the learner single judge has actually applied his mind and say, for what reasons he is giving these directions.
I'll
Only
suggest
two
this on-
components, the seniority cannot be disputed, cannot be contested,
But
and the other is the insurance. CR forms everything.
Your Lordship, the ratio is one for one promotion.
And there is no interview component for assistant manager, deputy manager.
True, Your Lordship, but in our promotional policy, Your Lordship, for one promotion, there will be 3 candidates. 1:3 at the ratio of that. Those who scores the highest marks, they will be considered, Your
That's
Lordship.
in normal circumstances, but these are not normal circumstances. That is when all three everything is there, ACR is there, seniority is there, insurance is there, interview is there, and 3 candidates are available or are being assessed. That is the criteria. But this is a case where for 10 years, this gentleman is not in place.
Yes.
No ACRs were written, nothing of that sort. What is the basis?
But
And he cannot be denied the promotion only because for 10 years you are away. You can't. You will presume everything is in just and proper for him.
But for his mistake only, Your Lordship, he was out of service for 10 years due to his own mistake and not because of the mistake on the part of the insurance company. He was caught hold red-handed by the Lokayukta while
So that has been set aside. For 10 years, how was he out of the job?
Your Lordship, he was not given a, he was given only a benefit of doubt. He was not given an honorary acquittal by the High Court, Your Lordship.
So finally, there was an acquittal in his favor. So how would you define acquittal? Acquittal is there nothing against him. Not even a benefit of doubt. Is it a case benefit of doubt?
And one more submission, Your Lordship.
Let's see that. Where is the judgment of the appellate High Court?
Yes. I'll get the judgment by next week, Your Lordship. We have not affixed that matter as a part of this.
ಜಡ್ಜ್ಮೆಂಟ್ ಕೋಟ್ ಮಾಡಿದೀವಿ ನಾವು
ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿ
ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿ ಹಾಕಿ ಇಲ್ಲಿದೆ ಇಲ್ಲಿದೆ ಕೋಟ್ ಮಾಡಿದೆ ಹಾಕಿ consequential benefits only for the purpose of retirement.
does it say benefit of doubt? Ah, is entitled to. Yeah, but how would you say this would be a benefit of doubt? See paragraph 39 onwards, page 194.
190. Hmm, 190, 190.
94. May I read?
You read it?
Yes, Your Lordship. As far as the ruling cited with the respective sides are concerned, there can be no two opinions about the principles laid down in all those cases, but as has been observed with the apex court and that once demand and acceptance is proved, the presumption has to be raised as per section 20 of the PC Act. In the instant case, the evidence on the whole does not lead to the irresistible conclusion that the prosecution has proved the case beyond reasonable doubt. The doubt which has arisen in the instant case are the doubts that emerges from the entire evidence on record. Therefore, it is not possible to take a view that the prosecution has proved the demand and acceptance of ₹1,000.
So stop here.
Yes, Your Lordship.
Prosecution could not prove.
Both together they have not proved.
Could not prove that prosecution proved demand and acceptance of ₹1,000. That's the point. So this is something which the prosecution was required to prove. It did not prove it. And then it goes on to narrate it till this para. If you read the further part of it, once the said test is not passed by the prosecution, the question of section 20 of the PC Act will not be attracted. In this regard, decision of the apex court this, then now just read this judgment will have to be pressed into service at para 36 of the aforesaid decision. The apex court has observed that the demand of illegal gratification by the accused has not been proved. Section 20 will not be attracted as the accused has been charged for commission of offence under this. Then it comes merely because there is a observation that it is appellant is entitled to the benefit of doubt at page 196. Yes. That does not mean it's actually a case of where a benefit of doubt has been. It's a case of acquittal. It's a case where the prosecution could not able to prove it.
That apart, Your Lordship, while this honourable court, while disposing the writ petition after remand from the honourable apex court in writ appeal 1904.
Show us that order.
Yes, Your Lordship. There is no, on page number 71, 1904 of 2008, Your Lordship. After remand from the honourable apex court to consider the matter afresh, Your Lordship, may I take Your Lordships to the page number 75, para 6, Your Lordship. Having heard the counsel for the parties, we do not see any error committed by the learned single judge for the following reasons. Admittedly, the respondent's services were terminated only on the ground that he was convicted by the special court, and admittedly, the conviction has been set aside by this court in a criminal appeal. When such being the case, we are of the opinion the learned single judge was justified in quashing the order of termination, which has been affirmed by the appellate authority. We have also seen that the learned single judge has observed that his order would be subject to the order of the Supreme Court, provided the matter is taken up to the Supreme Court against the order of acquittal.
Where is the learned single judge order?
I'm sorry, Lord. This is a division bench order.
Where is the single judge?
Single judge order is at page
64.
Were there any consequential benefits?
Yes.
Yeah, only regarding promotion, there was no mention.
No, consequential includes everything.
Your Lordship, I may kindly permit you, there are some citations which I have come across with that consequential reliefs, unless specifically stated about the promotions.
Ma'am, it's settled now. Consequential is everything which consequentially flow.
I may kindly be permitted to submit those citations also by the next, any date in the next week, Your Lordship, I'll get ready myself on, along with the judgments.
Yeah, nothing in this.
Next week itself, Your Lordship.
Difficult. Difficult.
I'll just take a chance, Your Lordship, by trying to convince this honourable court. I'll get some
on
judgments.
what point?
The same on consequential reliefs also, Your Lordship.
Ma'am, consequential, we are very clear. It will include promotion.
I'd like to put my efforts in that regard, Your Lordship.
Oh, no, I don't think so.
Date may kindly be given, Your Lordship. A date, any date in the next week may kindly be fixed, Your Lordship.
Oh, ma'am. Sorry. Clear, it's all clear. And there is a justification given by learned single judge, not in these facts.
Your Lordship,
We thought so. Initially, we thought so. Possibly the direction could not have been given. It should have been left to the DPC. But given the facts which we are in,
but our only.
what can be the material for the DPC even to consider it? Nothing.
Your Lordship, our submissions are that the learned judge has considered only the first two parts and not the remaining part. So far as
We are putting it to you.
so far as the experience part of it is and performance is concerned, Your Lordship, growth and the performance is concerned.
How would you?
But the other persons who were actually, who scored highest marks in that category, they have been already promoted, Your Lordship.
If he was not into that mess, he would have given,
That's exactly my submission, Your Lordship. That's exactly my submission, Your Lordship. Because of his own problem.
Because it is not because of his fault. Ultimately, he has been acquitted.
I'll get back, Your Lordship. At least 2 days' time may kindly be given. I'll get back to Your Lordships.
Otherwise, you would have subjected him to the DPC and all such other things and keeping this in a different silo.
Yes.
And worked out.
I'll
You
get
have
back.
not done so.
I'll get back to Your Lordships. I'll take
What part of his he has to undergo that?
a couple of days' time may kindly be given, Your Lordship. I'll get back to Your Lordships with the
We'll have it on Thursday.
obliged, Your Lordship.
The request of counsel for the appellant. We notify. Just a second. Okay. I have it. Come next.
56,
Just run through the list.
serial number 56.
We have the respondent number 3 in this case, my lord.
This case, I am appellant challenging. It has to be argued.
No,
Just say re-notify.
Already naila, sir.
49. Serial number 57.
That's a shorter date may be given, shorter.
Not possible.
Because trial court has said the benefit of maintaining the pay and use toilet should be given to me. There is no
Benefit
stay.
of?
Dispute pertains to maintenance of pay and use toilet. There was a lease agreement in my favor. There was a lease agreement in my favor, my
Give
lord.
it in August.
14-8.
Obliged.
57 urgent, 58. 68.
We'll have it some other day, re-notify.
59. 59. Government advocate.
This is for the respondent number 2, my lord. This is for the short accommodation to file
State
statement
appeal,
of
my lord.
objection for a removal of delay.
There's a short delay, my lord, in filing the appeal.
61 days delay, so.
At the request of counsel for the respondent number
2.
2. To file objections, re-notify on. Be filed within 4 weeks, rejoinder within 2 weeks thereafter, list on.
But he wants to file objection to the delay application.
Objections to the delay, just say.
Friday may be taken. Friday.
So, give the date.
8, 9.
Next.
Serial number 60. Tina.
Appearing for the
Appearing for
appellants, your lordship.
respondent.
Short accommodation, your lordship, senior is not aware.
At the request of counsel for the appellant.
My lord, I have a submission. Serial number 78 and this are similar matter. So it can be posted on 11th of July. On a similar matter, a PIL is also being heard on that date.
Who is the counsel in those matters in 78?
We are not appearing.
You are not.
78, one Mr. Subramanya, he is there.
You are there, we'll have it on that day.
Yes, my lord.
Just say that at the request of counsel for the appellant, re-notify on which date you said?
11th July.
11 July.
Yeah, along with WP 5
78 also re-notify on 11 July. You said 78, na?
Yes.
Serial number 78.
Re-notify on 7 July, 11 July.
Grateful.
61.
Yes,
Appellant. Notes,
it has to be heard, Mr. Ravi Shankar.
Can I suggest this, Notes, of course, subject to what my learned friend says. Notes, the orders passed which are under challenge are at the interlocutory stages. The writ petitions are still pending. The writ petitions are not yet disposed of. Notes, the learned single judge feels that the publishing of certain list by the Indian Nursing Council was restrained and therefore it should not have been done. That is the only issue, Milords. Now, if the same issue can as well be, Milords, re-agitated before the learned single judge, notwithstanding these orders, then I think the purpose would be served, Milords. Because subject to what my learned friend
Does he
says.
say, the learner single judge?
Milords, the learned single judge says that the Indian Nursing Council should publish the list of the recognized institutions. No difficulty, what we did, Milords, we will not have control over the Karnataka Nursing Council giving recognitions. So they will be having their own list, which will be web hosted in their website. So what we do is we will give the URL link. If somebody clicks on the URL link, they will get the list. What we are also doing is, we are under an obligation under the statute to conduct inspections under section 13. There is a regulation of 2020. There is a regulation of 2021. In the previous order, the learned single judge also says that the regulation is required to be placed before the houses of the parliament, and therefore it is not come into effect, which is not correct. At last case, Milords very specifically dealt with these three issues. So now, on the premise that the regulation is not in force, the learned single judge goes on to hold that the list which we are publishing of those colleges for which we have conducted the inspections and the result of inspection should not be published. Milords, I am under a statutory obligation to do it. Once I am statutorily bound to do it, Milords, in the era of transparency, I am only publishing which college I have inspected, what is the result. So now this writ petition is still pending. Milords, what the learned single judge does is restraining us from publishing the list. Milords, the list of recognized institutions we have not breached at all. We have maintained it. So there is no question of, but we have also given a parallel information regarding the institutions which we have inspected. So now the learned single judge even went to the extent of saying that suo motu contempt is to be initiated for publishing the list of institutions which we have inspected and the observations of the list of institutions. So that is the only order which is before your lordships.
Lord, the issue here is they claim to have given certain recognitions to certain institutions. The entire issue, my lord, is that in 2013, from 2013, multiple courts, including this honorable court, my lord, has stated that they do not have the power to issue any recognitions in the first place. What they do is, when the court stated that they do not have the power to issue recognition, they go ahead and replace the word recognition with the word suitability. They continue to do the same thing that the court barred from 2013 by way of new circulars and new laws that they bring in, only by replacing the word. So the very point that they say that we have inspected, the inspection was also for grant of recognition, which in 2017 the court said that they do not have
the power to grant
state government, which they also accept. Only state government has got the power. They're
on their recommendation.
No, my lord, they have got no role. Only role that they have is
Only
to regulating and to prescribe the syllabus, which is
But,
also upheld by this court. Categorically, it has stated that your role is only to this extent.
May I just
You
pass on
shall
the
not
Indian
go
Nursing
forward.
Council Act.
We'll have it some other day, Mr.
Yes,
Krishna. Appear for whom, Mr. Krishna?
Lords, he's for India. Indian Nursing Council is before the court.
the problem that we
Otherwise,
are
can I
facing-
also suggest, if your lordships,
problem that we are
lordships
facing,
may
Lord-
observe, my lords, that the writ appeals being pending. Lord, this is only on an issue as to whether we should go with the list or not. The main issue is something else before the learned single judge. One of the grounds which we have raised in the writ appeal is that was not even the plea before the learned single judge. The plea was not that this list is there, therefore it is affecting them in any manner, or that they should be hauled up for contempt. This was not the plea. This is what the court does suo motu. That being in its place, a lordships were to observe that the pendency of the writ appeal will not come in the way of we moving the learned single judge for disposal of the main matter. That would suffice, my lords. We will go before the learned single judge. Ultimately, that
Is that matter getting adjourned because of the appeal?
On this, they have been going on making a submission, my lord, that writ appeal is pending.
No,
My lord,
no,
what
my
has
lords,
happened?
It is
Shankar, it's your.
it is the other way around, my lords. What happened? The
Senior counsel is appearing first time in this matter, my lord. So he would not know
I
what
stand on
actually happened there in
instructions.
the
I stand on
remaining.
instructions, my lords. What happened? the learned single judge once observed what happened to this matter. Then they said a writ appeal is filed and the interim order is granted. So on that ground, my lords, the matter stood adjourned on one of the days. So therefore, my lords, this is carried forward by saying that the matter is pending. It is not with anything else because it was what fell from the learned single judge. But if your lordships were to make that, anyway, I think my learned friend is fair enough in saying that we will move the learned single judge, my lords, for disposal so that
You should not have any issue on this submission.
I do not have any issue on that, my lord. But our entire problem has been that it started with them publishing a list which they could not have published. That is how this entire thing started, my lord.
Tell us one thing, the issue which needs to be decided in this appeal
yes.
has to be separately actually adjudicated.
My lords, this, so far as this issue is concerned, my lords, is only out of the orders passed by the learned single judge. It remain.
Not, it is
My lords,
not.
whether statutorily we were required to maintain this record, whether we were under an obligation or whether we were fair to do this.
None of those, my lord. In fact, 2017, a judgment is passed stating that you do not have power to recognize. 2019, yes, yes.
Just re-notify the appeal on, just give it in August, September. To stop. We have been informed by the counsel for the parties that the two writ petitions being WP 972624 and
Lordships.
4721 of 24. That's right.
Yes,
That's true, my
yes,
lord.
madam.
Are still pending consideration before the learned single judge. The council requests that the observation be made by this court that the pendency of this appeal shall not come for the learned single judge to decide both the
So, lordships.
petitions.
And my
So great.
one more request.
Accordingly.
One more request, my lord. If they could stop publishing the list, that would be of much help until the disposal of the writ petition, my lord.
They can move
Because
it.
otherwise it's the same thing. We are at the same place. Since last 1.5 years, I have filed a writ petition. Court specifically stated.
We need to look into it. There is a stay of the order.
Yes, my lord, there is a stay of that order and this
Because
is
the
a stay which is
direction not to
operating for
publish,
past 1.5
that has
years.
been constantly been violated. That is why
Hmm.
court went ahead and passed an order
You're
stating
right,
that.
but there is a stay here.
Yes, my lord. Therefore, in the meantime,
That
if-
issue need to be looked into by us here.
yes, my lord.
The rest would be done by the learned.
Yes, my lord. Since this is not going to be looked into at this stage, my lord, I was hoping that if it could be not published until such point of time, or at least until disposal of that case.
That
Any
we have
such list. Because
essentially
I
a
will
main
be in
relief
again
which
a
they are to
stalemate.
seek, my lords, in the
I am ideally in a very stalemate situation, my lord.
But tell us one thing,
Yes, my lord.
this issue which is here
Yes, my lord.
has no bearing insofar as the writ petitions are
My
concerned.
lord, absolutely no bearing. For the reason
Go
why.
ahead then.
Not
Then
at
go
all.
ahead.
Not at all.
Argue that.
Yes, my
This
lord.
we will decide.
Not at all.
Yes, my lord.
Please.
That date may be at the shortest, earliest
giving you a
possible.
date.
Yes, my lord.
Interim order requires to be extended. my lords.
Interim order if you need to continue
Yes,
till the next date of it.
Lordships.
39,
What is the date?
62.
Please,
Lord,
ma'am.
if there could be a
I'm
shorter
appealing
date,
for
that's
the-
possible.
It's not possible.
Because of the admission season, my lord. The only problem is there are 600 institutions. They put up a list of 200 institutions and all the admissions are basically rerouted to 200.
It's not a recognition, it's only a suitability list.
It's basically they're rerouting the entire 600 colleges ki admission to this 150, 200 colleges they publish.
No, nothing
That is
like
what
that,
has
Your
happened.
Lordships. It's absolutely settled issues here.
3rd of September.
It's all settled. Great.
Please, my lord. I am appealing for the petitioner, my lord. Here, petitioners are the resident of Bailongal and they filed the writ petition in the form of PIL, my lord. My lord, here the petition property is survey number 174/2, my lord. Am I audible, my lord?
Yes.
Please, my lord. Here, my lord, the petition properties belongs to the local body, that is respond number 2, my lord. The municipality.
But how is the PIL?
Please, my lord, here the municipality granted this or sold the same property without complying the rule 39 and section 70. Please, my lord.
How is the public interest?
My lord, the properties belong to the government, my lord, and they without complying the 39, they granted the same land to the private person, my lord. May I brief the facts of the case, my lord?
Yes.
Please, my lord. Here, the petition properties belongs to town municipality, my lord, Bailongar. And my lord, the
petitioner and other resident of the Bailongal.
Just 1 minute. Have they
Please.
removed the objections? Huh? Issue notice.
I'm pressing for the interim order.
Yeah, we are issuing notice.
My lord, my only concern is, my lord, in the year 2002, my lord, without without notifying the same in the newspaper and without complying the rule 39, my lord, the whole property was granted to the third respondent without consideration, my lord.
You serve them, we have issued notice, serve the other side.
My lord, till that status may kindly be issued.
What are your instructions, man? It's all right, you must be having some instructions, no? Just say so and so accept notice for 1, let notice be issued to 2 and 3.
My lord, one submission, my lord.
Yes.
My lord, in the petition property, my lord, now the respondent number 3 is high-handedly and by using his political influence, my lord, he is constructing something, my lord, some rooms and he fencing the property, my lord, which is reserved for the public amenities.
Why don't you serve the other side?
My lord, we have served the government copy, my lord.
That's right, they have accepted notice, serve the notice also, court notice.
My lord, till that.
Just give it in July, ma'am. Next.
24/7,
Please, my lord.
serial number 63.
Appearing on behalf of our petitioner, my lord, requesting for short accommodation.
Just show this, ma'am. You want adjournment?
Adjournment.
At the request of counsel for the petitioner. Adjourn to.
49, 64.
Petitioners Council.
Yes, Mr. Fanindra.
This is a matter I had argued on the last occasion by Kudremu Kairanur Company, my lords, which is a central government undertaking. My lords, the issue relates to, I have all the clearances, mining lease granted, section 2 clearance under.
What is their stand, Mr. Fanindra?
My lords, they say now we don't trust you. That is the stand given by state.
The union, the state.
State says we have lost trust in you, faith in you in the statement of objections. My lords, the only interpretation that can be made, my lords, if your lordship kindly come to page 19, Annexure A. And by virtue of the final, the.
Which page?
19, my lords, Annexure A. That, my lords, is a government order dated 11/4. Sorry. Statement of objections. We have lost trust.
Yes.
Lords, at page 19 is the government order. It commences.
What is this?
Lords, this is where the land in question had been reserved for Kudremu Kairanur Company, my lords, for grant of mining lease under the provisions of the Mines and Minerals Regulation and Development Act. Since it's a forest land, lords, independently we have to secure clearance, pre-clearance under the Forest Conservation Act. So, my lords, the state itself recommended for stage 1 clearance from the MOEF. Stage 1 was given with certain conditions imposed. We complied with the conditions. State recommended for grant of final approval, which is known as stage 2 clearance to the Ministry of Forest and Environment. Stage 2 also granted. Now, while granting stage 2, my lords, in this, please come to page 21, my lords. 19 is the government order, which virtually, my lords, reiterates stage 2 clearance order of the MOEF. 19, my lords.
You said 21, huh?
It starts at 19, but if your lordship kindly come to 21. In that, please see the heading B your lordship should get. Conditions which need to be complied after handing over of forest land to the user agency by the forest department. In that, at page 22, Roman 8. The forest department shall ensure the user agency must do the needful as per Honorable Supreme Court directions and follow the instructions and recommendations of CEC and also take required approval in a time-bound manner for the regularization of violations in the Kudremukh Forest and National Park. It would be obligatory on the Forest Department and UA is user agency, to get the regularization of the violation of FC Act in the matter is done in time. Forest Department shall also ensure non-binding conditions laid down by the FAC in the matter. This is in respect of the other lease which was cancelled by the Honorable Supreme Court in a public interest litigation which was being held by Kudremukh. So the CEC was formed where the CEC was directed to give the recommendations. They have given certain recommendations where, my lords, we had constructed a dam for backwaters filling. That, my lords, they said about 348 hectares post facto approval you took. We have closed, the entire mining was closed pursuant to the Supreme Court's order and the CEC's recommendation. That we had to do. And there are lands and revenue lands belonging to us, certain private lands with buildings. So CEC said, my lords, certain buildings we can hold it. All other buildings have to be handed over to the state government. We agreed. We also gave a list for holding on certain buildings. And CEC recommended the cost of the building should be borne by the state, which is 25 lakhs for all the buildings. We agreed to that also because, my lords, we have to take care of the dam. The dam water today, there is a slurry, underground slurry pipe, lords, up to Mangalore port, because the Kudremukh iron ore has a pellet plant there, lords. So what would happen when the mining operations were being undertaken, the slurry would get transported through the underground pipeline. Now it is not being used, but it's used for transportation of water to the pellet plant. So only a few buildings are to be handled. Now, my lords, post facto, we have applied, that has to go through the MOEF. MOEF will then, my lords, levy NPV, whatever as per the recommendations. That we will have to do it. We have given undertaking, CEC is aware of it, everybody, Forest FAC is aware, MOEF is aware. So they have imposed this condition that after you get this lease, because we don't have any lease, we have a pellet plant where about 300 or 400 workers are lying idle. I have to pay salary to them. I have incurred about 800 crores on this lease itself for registration and all that. So, my lords, government passed an order, everything was in order. They also enclosed a draft forest lease agreement for my execution. We approved it, we said we are ready. After that, they are not coming forward to execute the forest lease agreement, nor handing over the forest land. While I have the mining lease, FC clearance, pollution control board clearance, mining plan approved by the IBM, and all workers in place. So, my lord, we had to ultimately come because this condition is only after they execute the forest lease agreement. Now they want this to be done prior to handing over the forest land.
What has to be done?
My lord, this Roman 8.
Roman 8.
Yes, my lord. Forest Department shall ensure the user agency must do the needful as per the Honorable Supreme Court directions and follow the instructions and recommendations of the CEC, and also take required approval in a time-bound manner for regularization of violations in the Kudremukh Forest and National Park. It would be obligatory on Forest Department and UA to get the regularization of the violation of FC Act in the matter is done in time. Forest Department shall also ensure non-binding conditions laid down by FAC in the matter. Now, all these things, in fact, the CEC has all given the recommendations, what we have to do. We are doing it. And we are a 100% central government company, my lords. I can't run away anywhere. Now, my lords, because I have this, and the Financial Investment Board of the Finance Ministry, with great, my lords, conditions, has sanctioned and spent 800 crores on this lease. The present lease, for which I had to pay NPV, stamp duty, is about 600 crores I have spent. Now I am unable to work. Workers are lying idle, and my pellet plant is almost coming to a closure. I am a mini Ratna company, my lords. All that I am saying is, since everything.
What is FC Act?
Forest Conservation Act, my lords. The MOEF stage 2 clearance, my lords, your lordships would get at page 58. That's the final clearance given. So once that is done, my lords, state has no role. Under the scheme of FC Act, it is only the MOEF, that's the Ministry of Environment Forest. That final approval is given. They have imposed this condition. For the other lease, which was closed, you will take steps to regularize certain things that, though we are not working, that closed in 2006. That will independently go on. If I have to pay fines, I'll have to pay fines because that's the order of the Supreme Court and the CEC. But for that, you can't hold me into this lease. And that's what the MOEF had said.
Now, what are they required to do now?
For execution of a forest lease agreement, and my lords, handing over the forest land, though, my lords, it is only in our state, mining lease deed is executed, under the mining lease deed, registered lease deed, they have put us in possession. But since it is a forest land, in our state, we also have something known as forest lease agreement on respect of the very same land. Though, my lords, I have...
You are in possession?
No, my lords, I can't be because they have to hand over this. Though under the lease, mining lease
Only
deed...
after the lease.
Under the mining lease deed, they say you are in possession.
That's right.
But under the forest, they say you have to get the forest lease agreement executed. And I am unable to work, though I have all clearances in place. I am legally, my lords, I have the right to work, and I am a central government company, 100% central government owned company. All the chairmen, everyone is.
And what is the state government's stand?
State government says you have committed violations in Kudremukh, that lease, till you comply with all the fines, NPV, penal NPV to be levied for that. We have lost trust in you, so we do not want to give you this land. And that is when, after all this is over, in fact, they recommended reservation of this area in my favor under the MMDRI. First stage clearance, state recommended. Stage 2 compliances, state recommended. Everything was over. Government order is passed to execute the lease deed. That's, my lords, on 11/4/2023 at page 19, which I read to my lords. It is only after that we have been going to them every time saying that please execute the lease deed because we are answerable to the Financial Investment Board of the Finance Ministry. We have to carry out, our workers are lying idle. I am paying salary to them. I am a central government enterprise. Let me work the area.
What is your stand on the penalties, everything, what they are now trying to impose on that?
Lords, I am saying that you cannot, ultimately it is only the MOF which will have to levy the penalty. They will have to calculate the NPV.
They don't have any locus?
They can't, my lords, because it will be only by the central government under the scheme of Section Forest Conservation Act. It is the MOF only which can decide, my lords. That's the rule.
Now, where is their demand for, where is their stand? What you are now saying?
Statement of objections. If your lordship takes their statement of objections, which has come for the first time. Please take their statement of objections. In that, please come to, if your lordships have the statement of objections by the state.
Where do they say?
My lords, please first come to page para 6 at page 8 of their statement of objections, my lords. Para 5 and 6, may I just read that? It starts with, it is true that the state government has reserved, your lordships have that, my lords, para 5. It is true that the state government has reserved 401.5761 hectares of forest land for mining of iron ore in Swamimalai forest block and manganese ore in Devadari Hill Range, Sandur Taluk, Bellary district in favor of petitioner company. It is submitted said extent of forest lands is virgin as on date and the forest lands are yet to be handed over to the petitioner company for exploitation of the mines. It is also true that the petitioner company has fulfilled stage 1 conditions forthcoming in the order dated 24/6/21 by the Ministry of Environment, Forest and Climate Change, Government of India. On the basis of compliance of the conditions in the said order, Ministry has accorded stage 2 approval to the petitioner as on 16/12/2022. The state government is now required to hand over the reserve forest lands to the petitioner company, and thereafter the petitioner company is required to fulfill the conditions as stipulated under condition B in the order dated 16/12/2022. Now they call out that condition 8 which I read in the next para, but please come to para 8. It is submitted state government in view of flagrant violation of orders, directions of the Honorable Supreme Court and recommendations of CEC by the petitioner company is contemplating whether reserve forest land in Bellary, which is still pristine and virgin, should be handed over to the petitioner company since the state government is not confident that the petitioner company will comply with stage 2 conditions. Now, my lords, this is the most shocking aspect of. And I have given central government undertaking has given an undertaking saying whatever CEC has said, whatever penalties will be levied, whatever conditions we are bound by the Supreme Court's directions, we will have to comply with it. If I do not comply, my lords, I will be hauled up for contempt, not here. I will be hauled up for contempt before the Honorable Supreme Court.
Yes, ma'am. We'll continue, Mr. Upanendra. We have to get up. Just give it, ma'am. When do you want to?
That's because there is extreme.
Yes, ma'am.
Please.
We'll have it on Thursday.
Thursday, please.
Thursday. Re-notify just.
For us, the interim order, what we are seeking is at least let us commence the mining. Because, my lords, otherwise.
Let us commence the
Mining, my lords, otherwise I am stuck here with all clearances in place. And, my lords, the finance ministry is on my head.
Thursday.
Please.
Thank you. Ma'am, do one thing. How many matters are there? Just give the dates. Just give the dates. Huh? Give the dates. We'll give you the rest of the matter. We'll give you dates.
Item 71. Item 71.
Yes, Mr. Bhutan.
That's that your lordships today wanted to take that matter actually.
I know it may be, I have a separate bench. It may not be possible. We'll give you a date.
Your lordships.
My lord, next week can be given for 71
Maybe there is
minutes.
an interim order. We'll continue.
My lord, your lordships, it's serial number 78. It's a,
We'll give you date.
my lord, we are before this court at least since 12 years. I am a pensioner. It is my 13th year. It is partially settled. I have been fighting.
Other side. Who is the
Yes,
other
it's
side?
a state appeal, my lord. This matter was heard and admitted, my lord, scheduled for final hearing now. We'll go ahead with the matter.
I have a small submission, my lord. When we came before this honorable court on contempt, they have come on appeal. We have the advantage of honorable single judge order dated 26/9/2023. When we came before this court on contempt, then they have come on appeal. We are again put to mental agony. We want a short date, probably Thursday, if not on next Monday, that is on 30th, my lord.
Which matter you said?
My lord, it is 76, my lord.
76, my lord.
Yes, quoted the wrong number.
We'll give you a date. Just give.
Please.
Short later, we will be much obliged, my lord.
Hope she calls me. Madam, serial number 71, madam. Is this the same court of? Court office is serial number 71.
ಪ್ಲೀಸ್ ಅವ್ರು ಹೇಳ್ತಾ ಇದಾರೆ ಹೇಳ್ತಾ ಇದಾರಲ್ವಾ. Just 5 minutes, just 5 minutes.
Just take it. Is it of this court? No? Oh, you are the appellant?
I'm the appellant, my lord.
What happened?
Twice it had come to High Court and to this very court, Your Honor, and the order was passed in my favor. But the previous judge has cancelled the confirmation order given by the BBMP and asked.
So today the order is against you.
Not against me, is asking the BBMP to renew the confirmation order.
So you are challenging the order of learned single judge.
Yes, sir. Yes, ma'am.
You'll have it. Objection. You have removed the objections.
For admission.
You have removed the objections in the appeal.
Yes, sir. Yes, ma'am.
Are you sure? You first check up that, then only you will mention the matter.
Can you put up the act tomorrow?
No, we will not. First, you have to remove the objections. You check up with the registry. When did you file this petition?
It was filed in WP 1929324.
No. When did you file this appeal?
29/1/2025. The
Is it a pending appeal?
No, the writ petition came to be allowed in part by the.
We are asking you about the appeal.
This is the first time I'm coming.
When did you file the appeal?
This file.
There is an FR number.
About 5 months back, my lord. I'm sure it's 5 months back.
This was on 29th of January 2025. Thereafter, around 5 months back, might not be 5 months. Thereafter, they have preferred to appeal. Might be in February or March.
The scrutiny branch took a long time.
Objections.
Yeah. Scrutiny branch, the objections have been removed 100%. That's why it took so long, my lord.
Objections removed? Give it next week. We'll review next week.
Can you give a date, my lord?
We'll give a date. Just have it next, whatever is convenient.
Appreciate it.
27/6.
This is
27/6.
This is our jurisdiction.
Much appreciated.
Yeah. Good afternoon, brother.
Hey, Ramesh.
Good afternoon, Chief. My lord, in this matter, my lord, I am appearing for the complainant. And I am filing an application for restore the.
By your submission, Mr.
My lords, the Tahsildar is present, my lords. The Tahsildar had come up before this court. My lords, what happens in this particular revenue entries is there are 10 steps which needs to be taken, my lords. First 5 steps were taken by the Tahsildar. Then it comes under the jurisdiction of the ADLR and DDLR, my lords. They were also parties before the writ petition court. Here the further development what's happened is in the appeal preferred by the state, in the revenue appeal preferred by the state under 108K of the KLR rules, my lords, on 20th of December 2024, there is a stay, my lords.
There is a stay of the
There
order.
is a stay, my lords. Yes. Not my lordship's order. The benefit under which they claim the grant, my lords, whenever there is a violation of grant conditions, before the AC they were successful. The state went in appeal under 108K.
Did the state went in appeal against this order of which compliance is sought? 15 February 2024?
My lords, the compliance is sought basing their grant to be crystallized by the order of the AC, my lords. But there is a statutory appeal provided before the DC, my lords. So on 2012-2024, the DC has issued a stay under 108K of the KLR Act. So the ADLR and DDLR are unable to proceed further, my lords. Notices have been issued.
That's one thing, Mr. Chandrasekhar.
My lords.
Now, which is the order of which contempt is alleged?
My lord, I will. My lord, order dated.
Page 28 may be kindly looked
That's
into,
right.
my lord.
3/1/2024, my lord.
28, no?
Page number 28, my lord.
So recording submission and advocate, the writ petition stand disposal granted you to file an application online to the respondent Tahsildar. Respondent is also directed to consider the application which would be filed by the petitioner and do the needful as expeditious possible within it. Now, this is an order under the in the writ petition.
Please, my lord.
Now, how are the proceedings before an AC or a DC have a bearing on this order?
My lords, Podi and Durust will depend on the claim of the documents in which they claim their ownership over the said property. Usually the same would be under the grant as such, my lords. So the grant with regard to, in their favor, attained finality before the assistant commissioner, my lords. Based on this, they came and told, we want the Podi and Durust to be completed. But there's a statutory appeal as against the AC's order, my lords.
Who filed it?
The state has filed it, my
Oh,
lord.
the state has filed
The
it.
state has filed it, the state has secured a stay. They are also parties to the same. Post disposal of the same, subject to the outcome of the
The
DC.
fact that there is a stay by the DC.
No, my lord.
I can
As
provide
per
the case
my lord,
number also
as
and
per
also the
government advocate-
details, my lord.
We will ask, yes, brother.
Chief, that is not the statement made by Tahsildar on the earlier occasion.
Please, my lord.
Statement of
My lord, and 2012,
AGA is
2024, my
recorded.
lord, they have stated, my lord, they have filed an appeal before the deputy commissioner on 2012, 2024. My lord, the contempt petition are disposed of on 16/12/2024, and that time, my lord, the present Tahsildar was present. They have stated, we have filed an appeal before the deputy commissioner, not they have stated before this honorable court. My lord, they have stated.
So when was the stay by the deputy commissioner?
20 post the statement made by the Tahsildar, my
Date was
lords.
given, date is very important.
The date. You ask
20th
the
of December 2024.
officer. See, this order.
No, my lord, they have taken undertaking before this honorable court. Then they have.
Clarify, my lords. I want to just verify on the dates, my lords. My lords, on 13/12/2024, the contempt was closed, my lords.
No, 16/12.
Okay, my lords, 16, I think I have just, on 16/12/2024, the Tahsildar had done his part because there was no stay at the relevant time, my lords. So on 2012, post the diligence done by the Tahsildar and forwarding the record to the ADLR and DDLR, the stays come on 20th December 2024. my lords.
Stay has come on.
4 days post 16th of December 2024. That is on 20th December 2024.
Do one thing, you will file a reply to this application.
Very much, my lords.
You put it on record. Yes, brother?
Chief, earlier one affidavit was filed, which came to be rejected by the court.
This
Quoting
honorable-
from, Chief, may kindly notice 2011-24 order, Chief, where the affidavit with a different stand. Each time Tahsildar is taking in this matter a different stand.
My lord, they have,
File the affidavit.
my lord, they have filed an affidavit on 29/8/2024. They have taken two stand, my lord. One, my lord, in this affidavit is stated application was rejected, but in the annexure B, R2, my lord, they have stated your application was allowed. For a moment, my lord, kindly see the affidavit filed by the accused, my lord.
No, we'll do one thing, brother. We will ask them to file a reply to this application.
Chief, please, Chief, please, Chief.
Let them
Or another aspect,
May I
Chief,
make
because
Yes.
as on today, they are admitting that they have not complied with their statement made before court. Chief, may kindly consider to restore the contempt petition so that it can consider in detail.
You will.
My lordship should restore the same. Then only we could file the apply, my lords, the reply. May I make one more request, my lords? Can they implead ADLR and DDLR? They would be the necessary parties, my lords.
The direction was given only for the Tahsildar is
My lord,
the first
as a
single judge.
as a representative
No, my lord,
of
they
the
are-
state, I'm telling two more officials.
even though, my lord, the state is the state was perform, the second respondent is the.
What prejudice would be caused if they are able to implead other two authorities as such, my lords?
First revive it. Let's revive this.
Very much, my lords.
This is an application filed by the petitioner seeking revival of the contempt petition and for the restoration of the same to its original file. The contempt petition was closed in terms of order dated 16 December 2024. Contempt petition was closed with the direction that the rest of the exercise shall be completed within a period of 8 weeks from today. The submission of learned counsel for the petitioner is that the exercise has not been completed.
Please.
Completed till date.
Till date, my lord.
Full stop. He seeks the revival of the contempt petition. Full stop. The learner, Mr. Chandrasekhar, appearing for the respondent, along with the Tehsildar, states that they have no objection if the contempt petition is revived to enable the respondents file an additional affidavit as to what steps they have taken, what step to ensure the compliance of order dated 13/12/24. 13/12.
No, my lord.
No.
15/12/2024.
No.
Annexation.
Comply with the order dated 15 February 24.
Please, my lord.
15 February 24 in writ petition 449 of 24.
Please, my lord.
And also 16 December 24
Please, my lord.
in the present contempt petition. So they shall file the affidavit within how much time?
Whatever time, my lords.
Within say 3 weeks. Within 3 weeks, list the contempt full stop. List the application for revival is disposed of by directing that the contempt petition stands revived to its original number. List the contempt petition on.
May I just take one indulgence, my lord?
May-
Para 3 of the order, my lords. Why I am making the submission to implead ADLR? If my lordships were to see para 3 of the order, my lords. Very much,
We
my
are
lords.
keeping it open.
Very much, my
On
lords.
your affidavit to come, we want to see who was under the obligation to comply with.
Please, my lord.
Even the person, the authority which I am seeking to implead, even that authority is answerable before the court, my lords.
We will,
That would make my job easier is what I am trying to
appreciate.
convey.
But the only thing today, what impression we are getting is because of the stay order, you could not take it further.
Please.
The subsequent authorities couldn't take it further, man.
No, very well. What is the role of Tehsildar for taking it further?
Tahsildar, till that date, whatever he had to comply, he has complied, my
Say
lords.
so, we will see.
Very much, my lords.
And you must say so that who was to take it further.
It's recorded at para 3 of the order also, my lords. That's the only reason I wanted my lords to peruse the said para.
My lord, one more request, my lord. I have filed an application for delay, condonation of delay, filing the rest
How much is the delay?
of 15 days, my lord. 1 5.
Condone, delay, condone.
Obliged.
Thank you, brother.
Obliged, my lord.